Okay, all right. So, good morning, everyone. Let me call the meeting to order. This is the Council on Access and Fairness, and this is actually the last meeting of the 2019 to 2020 term. I want to welcome you all to our final meeting. With respect to, let me just ask Elizabeth to go ahead and make the announcement regarding the use of Zoom and take roll.
Sure. So welcome everybody, COAF members, liaisons, and members of the public to our COAF meeting, and a special welcome to our incoming 2020-2021 members for joining us today. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please type "I have a comment" or "I have a question" in the chat box, and a message will be sent to the host. Alternatively, you may raise your hand. There's a raise your hand feature so that we can queue up who will be next in line to make comment or ask a question. In an effort to be transparent for all those joining this public meeting, whether by Zoom or phone, we request that you refrain from having any side conversations or chats about the content of the meeting. Again, the chat feature is utilized simply as a tool for you to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. Please note that all COAF meetings will be recorded and posted to the State Bar website. This is also a friendly reminder that this is a video conference, so please be aware of your surroundings behind you. Some troubleshooting tips for those of you using Zoom on your computer: when you are muted, you may press the spacebar down to temporarily unmute. If you would like to use your phone to dial into the meeting, please be sure your computer's microphone is muted to avoid any audio feedback issues. When joining audio via your computer, which is highly recommended, if you do lose audio, please try to call in separately using the Zoom conference number. So those are our housekeeping announcements.
Thank you. Can you please take roll?
Yes. Judge Brenda Harbin-Forte.
Here.
Judge Esther Kim.
Here.
Heather Anderson.
Here.
Hani Broussard. Okay. Ryan Harrison.
Here.
Genevieve Jones-Wright. Genevieve was here.
She's here. Oh, she just took her name off of mute.
Can you hear me?
Yes. Okay.
Present. Thank you.
Thank you. Emily Quinlan. Judge Kristen Rosie. You're muted.
I'm here. Sorry.
Thank you. Donna Shealy.
Here.
Sal Torres. Okay. And then our liaisons: Pat Lee.
Here.
Ken Wang. Judge Erica Yu.
I'm here, thank you.
Hylan Chen. Jose Cisneros.
Here.
Thank you. And then State Bar staff: Crystal Bundang.
Here.
Erica Carroll.
Here.
Greg Shin.
Here.
Duan Nguyen.
Here, Elizabeth.
Okay. Christine Holmes.
Here.
Brady Dewar. We have a quorum.
All right. Thank you. Now that a quorum has been established, let me call for public comment. Members of the public can at this time make any comments on any item on the agenda. Please note that the chair reserves the right to limit the duration of public comment. I'm going to now invite any member of the public to make public comments on any item on the agenda. All right. Hearing no public comments or any requests to speak, correct, Elizabeth? No hands are up or anything? All right. Very good. We'll move on then to the next agenda item, which is the chair's report. And I will just indicate, I'll say bye, I think maybe at the end of the meeting. But this is my final chair's report. It has been a real honor to have served as chair of the State Bar's Council on Access and Fairness. It's been a great group of people to work with. And we have gotten so many things done. I'm very proud of the accomplishments that we've made during my tenure. Staff has been absolutely wonderful, and the COAF members have just been incredible. Your dedication, your commitment, your passion, and your compassion are just unparalleled. And so I just want to thank you. It was an honor and a privilege to have worked with you. Let me introduce let me thank the outgoing members who will be joining me. This will be their last meeting as well. And I hope they're all here. If not, we'll thank them anyway. Connie Broussard. Connie, if you're there, again, I want to thank you for your dedication, for your hard work, for your initiative, for your creativity. I can say this actually for all of you. You have always had wonderful contributions to COAF. And you have all worked very hard on your subcommittees and at our meetings. But I want to thank you, Connie. Genevieve Jones-Wright, I want to thank you as well. I'm going to incorporate by reference everything that I said about Connie. You've been a wonderful addition and member on COAF, and I really thank you for everything. Emily Quinlan, similarly, everything's adopted by reference. The previous comments are incorporated by reference, and I thank you for everything and your hard work. And Donna Shuley, I just can't say enough about you. Donna, I really, again, everything that was said before, of course, but you have been so committed to COAF and done such a done all the hard work to make sure that COAF stays on track, and that we do what we can do to improve in terms of the state bar, diversity in the profession. And you've been a conscience of COAF, and I want to thank you for your hard work.
Thank you so much.
You're welcome. And so, can we just kind of give a hand to, if we were in person, I'd be going around handing you your certificate of appreciation and everything. So I'm going to ask you to just kind of pretend that you've been presented your certificate of appreciation. And can we give a hand to our outgoing members? Some of you are muted, but I want you all to know that there's just a thunderous ovation for you. Okay, why don't we move on then to introduce actually, yes. Please identify yourself. There's a lot of feedback. Who was that? Elizabeth?
I'm not sure.
That was the 818 phone number ending in 75.
Oh, it might, I think it's,
Yeah, I'm.
Is it Donna?
so Donna, you've joined us on your computer, I think.
Yes, I was able to get in. So sorry for the feedback of getting rid of my phone on there.
Okay, well, welcome back.
Thanks.
Okay. Then let me move on. I want to introduce the liaisons. First, from the California Lawyers Association, and that is Kenneth Lang. He's not on yet, correct? Has he joined us yet?
He hasn't joined us yet. I think he may be joining us a little later this morning.
Okay, and Pat Lee, who's the liaison from California Law. And Pat's on already. And then there's Judge Erica Yu, who will be the liaison from the Judicial Council. Welcome to all of you again. We met Pat and Ken last month, I think, or definitely Pat. And so we have Judge Erica Yu. Judge Erica Yu and I go back, as far as Pat Lee and I go back. We've been partners in crime since, actually since before then, before the 2005 Diversity Pipeline Task Force, when we paired up to get together that very first diversity summit in 2006. Judge Yu was on the courts working group subcommittee. So we have been raising sand and getting into good trouble for all of these years. So I thank you. I'm glad to have you all. And Pat, of course, we could not have done any of that without you being there. Pat was staff person to our subcommittee and has been with the State Bar throughout until, 2 years ago, I guess, Pat. I'd like now also to introduce the new members, and that is the new members for 2021. And you'll be beginning your term in September. That is Novella Coleman. Hi, Novella, welcome. Sarah Good, you're there, hi. Michael Rhodes, hi, Michael. Shalak Richards is there. And Stephanie Chu Santoro. So I want to welcome you to COAF. I'm sorry I won't get a chance to work with you, but I know that you will do wonderful things. And you will be doing that under the leadership of two fabulous people. The incoming chair will be Judge Esther Kim from Los Angeles Superior Court, and also Ryan Harrison will be our vice chair. So it's going to be a wonderful one. You know what, I'm not going to just ride on off into the sunset. I'm going to be around. I'm going to be sending emails to everybody and harassing people and checking in. And please feel free to call on me if there's anything that I can do for you. Okay, so thank you all. Let's see, we're not going to—
Judge Brenda,
Yeah.
Judge Brenda, before we go on, I'm actually glad that you said you won't be riding off into the sunset and that this is recorded, because we will be calling you, we will be emailing you. And as most of you know, Judge Brenda Harbin-Forte has been a pioneer in diversity. She has dedicated her entire career to diversifying our legal profession. And let me tell you, as the vice chair last year working with Judge Brenda, I don't think she sleeps. Because she would send me emails and she, in everything that she does, you could see where her heart is. And that really is for diversifying the profession and for mentoring. And the first time I met Judge Brenda, I had my application in. And when I first joined the council several years ago, I shared with her that I had my application in, and every single meeting and emails in between, she would ask me how that process was going. She would ask, what can I do to help? And again, I think that just is just a small preview of her heart, not only for mentoring, but for really everyone in the legal profession. And so while we would have done this in person, we have a small gift for you prepared by the council. And it's a crystal gavel because, of course, Judge Brenda just shines wherever she goes. And it says, in appreciation to Chair Judge Brenda Harbin-Forte for your dedication and commitment to the Council on Access and Fairness 2019-2020. So we want to thank you, and I will send this by mail, but I did want to present you with this wonderful plaque. And this is just a small token of everything that you've done for us. So thank you.
Oh, wow. This is so touching. Thank you so very, very much. Thank you all. Oh, gee. Thank you. Thank you, Esther. Thank you, everyone. This is emotional. I don't want to leave. I think I'm going to.
You're not going far, Judge Brenda. We know.
You
said it, so you're not going far.
I'm going to contest the election and stay in office. You know? Okay, okay. All right, thank you all so very, very much. It really has been an honor and a privilege, and I couldn't have done anything or have made had any successes without the people who were really the wind beneath my wings and who said, let's go for it. I'm gonna be in that arena with you and I'm gonna be fighting with you. So I thank all of you for that. And Esther, you've been a wonderful, wonderful vice chair. You know, we've been partners in crime on some things. You know, we can't tell everybody what we were doing and plotting, but that's okay.
This is recorded, so let's not talk about that.
Yeah, that's right. You know, that is true. That is true. We know the good, the bad, and the ugly, but we shall always only talk about the good. So, all right, very good. I'm going to take some things out of order now. We're going to pass the consent calendar, and we will then now move on to our state bar reports. Is that correct, Elizabeth?
That's right. So
All right.
we have Melanie Lawrence from the Chief Trial Counsel, and Dag McLeod and Ron B. to talk about the attorney discipline system.
Okay.
So Melanie, I think you're going to share your screen.
Yes, I will. Good morning, and thank you for having me. Can everybody hear me okay?
Yes.
Yeah, and
Okay.
welcome, Melanie. It's good to meet you. You're the interim chief trial counsel, correct? And
I
you've been you've been interim chief trial counsel for how long?
For over 2 years now.
Over 2 years now. Okay.
Yeah.
All right,
And
very good.
And to give you a little bit more background on me, I have been with the Office of Chief Trial Counsel for going on 15 years now. I started as a line attorney, so I've tried all kinds of cases, and in about 2012, I moved into a management position. And as you noted, I've been in the interim position for now over 2 years. So, you know, I'm here to give you an overview of the discipline system. Given my experience with it, hopefully I will be able to answer all of your questions. But if you pose one that I can't answer, I'll let you know that and try to get you the information later.
Okay.
So with that, I am going to go ahead and share my screen. And so I'm going to go through some slides, and I do imagine that you will have questions. I'm happy to answer them as we go along. Now, I can literally on the Zoom feature here see myself and 3 of you, although I know that there are 30 plus of you out there. So if I don't see you, you know, and you have a hand raised, somebody can let me know.
I can help you with that, Melanie. This
Perfect.
is Elizabeth.
Excellent.
Yeah.
Okay, I appreciate that. Okay, so let's get started. First of all, to give you an overview of our work, last year in 2019, we had 16,200 cases come through our office. And of those, we filed 619 disciplinary matters, and the State Bar Court recommended or imposed discipline in 532 matters. The Supreme Court disbarred 117 attorneys and suspended 137. So to give you an idea sort of in terms of these numbers, in October of 2018, we began accepting complaints online. And as a result, from about October 2018 to around July 2019, we really saw record numbers of complaints. We saw a number of complaints coming in through the online portal, but we did not see a corresponding decrease in the number of complaints coming in by mail. So we had quite a volume of complaints. Interestingly enough, since July 2019, we actually have now started seeing a steady decrease. That's been particularly true in these times of the pandemic, but even before then, we started seeing a decrease. And interestingly enough, on a national level, it appears that other disciplinary agencies are having the same experience, that over the last few years, they've seen a steady decrease in the number of complaints, and there's no real understanding as to why that might be, whether it's actual less attorney misconduct or simply less reporting of attorney misconduct. That's really not clear. Also, when looking at this number 16,200, This represents all of the cases that OCTC handled, so not just complaints, but other types of cases, and I will talk a little bit more about what those other types of cases are as we move forward here. So the sources of the complaints that OCTC sees primarily are from clients, and we are complaint driven. So for the most part, we don't initiate investigations other than in some limited situations, which I'll talk about here when I get to the bottom of the slide. But for the most part, clients are complaining. We also see complaints from opposing counsel, courts, non-client members of the public. These could also be, for example, friends of clients, family members of clients. There are also some ways that there are entities that must mandatorily report misconduct to us. So attorney licensees have their own reporting requirements when certain types of conduct occurs. Banks also, so for example, if there is non-sufficient activity going on in a client trust account, they are required to report that to us. That's something that you'll hear a little bit more about later on in the presentation. I understand you're interested in hearing some information about where we are with the recommendations made by Professor Robertson. So we'll touch on this area in particular. Courts also are required to report certain types of misconduct, as well as district attorneys' offices and insurance companies. We also do, as I mentioned, have State Bar initiated investigations. This occurs most commonly when, for example, we see a headline, something in the media about potential misconduct, and it hasn't otherwise been reported to us. Also, it could happen that while we are investigating a particular complaint, it may implicate another attorney, and in that case, we would potentially open up a complaint against that other attorney and investigate. So let's talk about the life cycle of a complaint, and I will get into some more details a little bit later after this slide, but this is an overview of the life cycle. So all of our complaints start in our intake unit, and to give you an idea, we have offices located in both Los Angeles and San Francisco, and our office is made up of approximately 280 staff. And those, are attorneys, investigators, support staff, paralegals, etc. At the intake level, it's generally staffed with attorneys, and they are reviewing those online complaints as well as the written complaints that come in. At this stage, what the question is if you were to look at the four corners of the complaint, if everything stated were true, would it amount to an ethical violation? And sometimes it's not entirely clear because we may not have enough information. If that's the case, we do try and reach out to complaining witnesses and get the information we need in order to make a determination. At the intake stage, generally speaking, the respondent attorney is not contacted. So if the complaint is closed in intake, it's possible that the respondent attorney would never know that a complaint had been filed against them. If the answer, in most cases, if the answer is yes, that if everything stated was true, it would amount to an ethical violation, then the complaint will move forward to the investigation stage. Now, approximately 40% of complaints do close at the intake stage. So we're looking at approximately 60% moving forward to the investigation stage. So once it moves forward to investigation, the complaint is assigned to an attorney who oversees the investigation, acting as the legal advisor, and to an investigator to actually work up the complaint. And during this process, we use all sorts of investigative types of tools. So for example, we subpoena documents, could be bank documents, could be court records, insurance records, etc. We also interview witnesses. Certainly we contact the complaining witness to do an interview. There may be other percipient witnesses. In the investigation process, we also contact the respondent attorney. So by rule, we are required to contact the attorney to give them a summary of the allegations and an opportunity to respond. And it does happen on occasion that respondent attorneys ask for extensions of time to respond. And if there's good cause, we do allow that. It's also possible during this stage that the attorney may look to representation. There is a organization called the Association of Discipline Defense Counsel. Some common respondents attorneys that we see that the respondent may engage at this time. Again, you'll hear a little bit more about that because it's part of the Robertson recommendations in terms of representation of attorneys. There is a business and professions code statute that requires attorneys to cooperate with a state bar investigation. So if a respondent attorney determines not to actually participate in the investigation, that potentially is a standalone violation in and of itself. So also to give you an idea, by statute, our statutory goal is to resolve cases in 180 days. And the reality is that in many instances, we're not able to do that for a variety of different reasons. One being just the sheer volume of cases that we have. And also a lot of our work is dependent on other people. So for example, when we send subpoenas, whether or not someone is responsive in time or not, whether a respondent attorney is responsive or not, and a variety of other kinds of issues like that. Also during the investigation stage, we may take depositions of the respondent, complaining witness, or other percipient witnesses. At the conclusion of the investigation stage, the question is whether or not we have enough admissible evidence that if we were to bring charges, we would prevail on a clear and convincing standard. So our burden of proof is clear and convincing. And if the answer is no, then the case will close at the investigation stage. There could be other ways in which the investigation resolves, and I'm going to get to that in a little bit. But if the investigation is going to move forward to filing, the case is handled by the same attorney that oversaw the investigation, and the attorney will then work it up for filing formal disciplinary charges. Now, during this stage and prior to filing disciplinary charges, by rule, the respondent attorney has the opportunity to participate in what's called an early neutral evaluation conference. It's essentially a pre-filing settlement conference. So what we do is when we're ready to actually move forward for filing, we've drafted a notice of disciplinary charges, which is our charging document. We send a letter to the respondent attorney, letting them know essentially this is a summary of the charges that we expect to proceed on, and you have an opportunity to participate in a settlement conference. And if the attorney elects to do that, then the parties try to agree on a mutually manageable date, as well as working with the court to schedule a date. And if it goes to a settlement conference, then a state bar court judge will actually conduct a settlement conference. And it's typically done in a caucus format. And we are doing those now by Zoom. So we try to resolve the case, if at all possible, at this pre-filing stage. And if we can resolve it, then our office will draft a settlement stipulation. So, and that includes basically, you know, all of the relevant facts, conclusions of law, an analysis of the recommended level of discipline, and it also includes factors in aggravation and mitigation that eventually impact the level of discipline. And then that is submitted to the settlement judge for approval. If the case cannot be resolved at this stage, then we go ahead and file the notice of disciplinary charges, and then the formal proceedings begin. Now, I should also mention that up until the time that the notice of disciplinary charges is filed, the entirety of the process is confidential. So it's not until there's an actual filing of a notice of disciplinary charges, or if we were to file a stipulation to settle the case, then it becomes public.
Melanie, Judge
Yes.
Brenda has a question
Sure, absolutely.
or comment.
Thank you. I wonder if we can get some percentages for the next step in the investigation. You indicated that about 40% of the cases end at the intake stage, after the intake stage.
Yes.
And so 60% go on to the investigation stage.
Yes.
Approximately how many, if you know, what percentage are closed after the investigation stage with no further proceedings? Do you have any idea of that?
So I can't tell you what the percentage is, but I will tell you that the large majority of cases close then at the investigation stage. The fact is that by the time we get to the pre-filing stage, and certainly by the time we get to the filing stage, there are many, many fewer cases that move forward to that stage. But that's a good question. It's something that I can follow up with you about.
All right, great. Thank you. And in part as part of the investigation stage, as I understand it, there is before it actually gets to the dark blue, the hearing and the trial, there is the sort of the pre-trial aspect of it in terms of trying to see if you can work out a resolution.
Yes.
Before you file the formal notice.
That's right.
Okay. All right. Thank you.
That's right. Sure. Okay. So if the case is filed with a notice of disciplinary charges, then we move forward with a formal disciplinary proceeding. Now, I will say that even before we get to a trial, there is another opportunity, at least formally, to settle the case. Generally, the court will schedule a voluntary settlement conference similar to the ENEC process, where we will go, and again, it's a caucus format, and try to settle the case. Also, for purposes of trial, the case is always assigned to a judge who did not serve as the settlement judge in the early neutral evaluation conference, and also it goes to a different judge for purposes of the voluntary settlement conference. So this is, the hearing is essentially, it's a trial. It's obviously before a judge, so there's no jury or anything like that. It looks similar to any other kind of trial in that we call witnesses, we offer exhibits as evidence, and we make closing arguments, we file closing briefs, etc. We can call the respondent, and often do in our case. And again, as I mentioned earlier, we do have the burden of proof, and it's clear and convincing evidence. And we are doing these trials by Zoom now, and that's been an interesting new world. It's had some challenges, but for the most part has gone okay. So the rules of evidence follow the Administrative Procedures Act, so they are slightly more lax than in criminal court, for example. And once there is a finding of culpability, so typically what will happen is the court will make a determination at the close of the evidence whether or not the court finds a tentative finding of culpability. And if that in fact happens, then the hearing moves into the aggravation and mitigation phase. And that really is, what are the factors that might aggravate the level of discipline? What are the factors that might mitigate the level of discipline? I'll talk a little bit more about that in a few minutes, but obviously we have the burden of proof to demonstrate aggravation, and the respondent attorney has the burden of proof to demonstrate mitigation. So once the case is submitted to the court has 90 days to issue a decision. And also I should note for you that the State Bar Court in most instances doesn't actually have the power to impose discipline. They have the power to impose discipline only in cases where there's going to be a private reproval or a public reproval, but anything above the reproval stage ultimately has to go to the Supreme Court, and the Supreme Court is actually the entity that imposes discipline. So at the hearing level and later at the appellate level, the State Bar Court is merely making a recommendation as to the level of discipline. And so that's going to be true also for when we are filing a stipulation to resolve a case, that the court's approval is merely a recommendation to the Supreme Court to actually impose that discipline. So at the conclusion of the hearing proceedings, once the trial court makes a decision, they will write up a full opinion and analyze the facts and the conclusions of law, again, aggravating, mitigating factors, and make a recommendation as to level of discipline. Both parties have the opportunity to appeal to the review department of the State Bar Court. So it is an appellate level court. There are 3 judges, and those judges then will make a determination. It works the same kind of way. So we we do briefing. There is an oral argument. Again, we're doing those by Zoom now. And at the conclusion, the review department will issue an opinion. After that happens, and because the Supreme Court is ultimately the entity who actually imposes discipline, either party can petition the Supreme Court for review. Obviously, it's a discretionary review on behalf of the Supreme Court. They historically have not taken a lot of our cases. So oftentimes this is where the decision ends, in that in most instances, the discipline is thereafter imposed by the Supreme Court. And the process, if the case is going to go through the review department from hearing to finality, will certainly be more than a year and upwards of 1.5 years before there's actually a conclusion. At which time the Supreme Court will issue an order of discipline. So, so the purposes of discipline overall, and what we keep in mind as well as the courts, are the protection of the public, the courts, and the legal profession, and the maintenance of the highest professional standards and preservation of public confidence in the profession. So it's not punitive in nature. So, and when we talk about level of discipline and how sanctions are determined, there are standards for attorney sanctions for professional misconduct. They're sort of akin to like a sentencing guidelines kind of idea. The standards are quite broad in many instances, however, so we oftentimes look to case law to determine appropriate level of discipline depending on our facts and other factors, including aggravation, mitigation. But levels of discipline are determined, as I noted here, based on the State Bar Act, the case law, and the standards, which are afforded great weight by the Supreme Court. So outcomes of a case that could be otherwise non-disciplinary. So in the investigation stage, and this could also happen at a pre-filing stage, is if, first of all, the first one here is certainly a case could be closed because there's not sufficient evidence. And that could happen at the intake stage and investigation stage, or if something changes at the pre-filing stage. Just by way of example, sometimes we have respondent attorneys who do not participate in the investigation, but they sort of come alive later in the process and maybe give us some information that we didn't otherwise have that changes how we view the case. But some other options that might resolve a case is, for example, a resource letter. So this could happen at the intake stage or later. And what this is if it appears perhaps not that the conduct amounts to an ethical violation, but that there's some concern about the attorney's practice. So for example, if we're getting a number of complaints related to a lack of communication on the part of the attorney, we may issue a resource letter, which basically says, hey, we've had these complaints. It suggests that there might be something going on in your practice that you may want to attend to. Here are some resources. We might refer them to the ethics rules by themselves, ethics opinions, client trust account handbook, or ethics school, something like that. But it's non-disciplinary in nature, but just trying to give them some resources and just note for them that there might be a problem here. We could also issue a directional letter. This also is if we've determined that there may not be enough evidence of misconduct, or that if they were to attend to something quickly, it could be resolved without discipline. So an example of this might be the client's complaint is that they've tried to contact the attorney to get their file back. And depending on how much how many resources they've invested in trying to do that, if it's just, a few times and the attorney hasn't necessarily been attentive, we will send a letter. Sometimes that will get their attention to say, hey, this client is asking for their file back. We want you to give them the file back. You have 30 days to give them their file back. And then if you fail to do so, then it could potentially warrant discipline. And that oftentimes will resolve the case. We could also issue a warning letter. So a warning letter is issued when there's low-level misconduct and when there's not been harm to a client. Also where it appears that if we were to issue a warning letter, that it would resolve the conduct. So this is someone who we're not seeing repeated complaints about, for example, or who hasn't had discipline in the past. So we may issue them a warning letter, which basically says there's substantial evidence that you've committed this particular ethical violation, and you should be aware that if this behavior were to continue, that you could be subject to discipline in the future. We could also issue a warning letter with conditions. So a condition might be that we want them to attend client trust account school or ethics school. And we usually give them 6 months to do that. Assuming they do that, the case is closed, and hopefully we don't see them again. That's the intention. It could also resolve with something called an agreement in lieu of discipline, or an ALD. And what this is basically, there is evidence of misconduct. Again, lower level, somebody hasn't been harmed, not likely to repeat. And so we basically enter into a contract, if you will, with the respondent attorney, where there is an agreement on all of the facts and the conclusions of law. There oftentimes are some conditions that they have to meet. Could be similarly to what I referenced earlier, could be ethics school, could be client trust account school. Usually they have to send in reports on a regular basis, which basically says, I'm compliant with the conditions included in the agreement in lieu of discipline. I haven't committed any ethical violations. And if at the conclusion of the ALD period, which is usually about a year, everything has been completed, then the case is simply closed, and that is not considered a record of discipline. Another resolution might be a referral to a lawyer's assistance program. And I guess this isn't necessarily a formal resolution in and of itself. Frankly, the resolution would be a closure, but with a referral to the lawyer's assistance program. And where this might come up is, for example, if we have a first-time DUI conviction. We typically do not prosecute first-time DUI convictions. I say typically because it's possible that we would prosecute a first-time DUI conviction if there is something aggravating about it. And when I say that, I mean things like there was also evidence of child endangerment, perhaps because there was a young child in the car, but the actual charge was dismissed at the criminal court. Or perhaps there's evidence of a hit and run that also occurred. We might actually prosecute that. But generally speaking, for a first-time, just a standard first-time DUI, we wouldn't prosecute it, but we would actually give the lawyer information about the lawyer's assistance program so that they could follow through with that if they chose. Okay. So potential disciplinary outcomes. And again, this could be by way of stipulation with our office or after trial. So the respondent attorney, if upon a finding of culpability, could be privately reproved by the court. And usually what that means, it's a 1-year period of reproval. They have to usually fulfill some conditions, which oftentimes will include things like you've heard before, for example, ethics school. Also doing quarterly reports, which usually go to our Office of Probation. They are the ones that are monitoring the reproval conditions at this point.
Melanie?
Yes.
Sorry to interrupt. Judge Brenda has another question.
Sure, absolutely.
Just Kristen, I think, as you know, COAF has been concerned with the disproportionate imposition of discipline on attorneys of color, and in particular, African Americans, and in particular, African American males. Do you have, or will you be able to provide percentages and also the ethnicities of the people who have been, where there's non-disciplinary action and disciplinary action? Are you able to provide the percentages? For example, how many white attorneys, how many African American attorneys, how many API attorneys, Latino attorneys, how many women attorneys, how many solo practitioners, as opposed to big firm? Are you able, because I think that really that's COAF's concern, is my concern. Where is it, what are the off ramps for in the discipline system? Who is benefiting from those off ramps before discipline, and whether there is a disproportionate impact, again, based on ethnicity or gender?
So with regard to your question about percentages, I rely on my friends in ORIA to actually produce data. And so I would have to refer you to them, which I know they're on the line, what could be actually produced. Now, what I will say, I think that they would say too, is when it comes to the question about solo versus firm, I think that it's likely that, at least historically, that's probably not information that we had, because I'm not sure that the bar as a whole collected it. Although I know that, I think as early as last year, perhaps the year before, that that was part of the questionnaire that attorneys completed when they renewed their licenses every year. But for purposes of some of these other questions, I think Oriah, who's going to talk a little bit later, might be able to touch on that. I think there's probably some information that we could potentially provide. And then also, let me just ask you, because I want to be clear about what you're asking me. When you refer to off-ramps, can you tell me what it is that you're talking about?
At the beginning, you talked about the closure after the complaint stage. So that I view as one off-ramp. So you get so many cases, 40% of them you close upon receipt of complaint, basically, or after preliminary review. So that's one off-ramp. And so we don't really have to worry about those, except to the extent we compare how many, from an ethnicity and gender basis, how many got the advantage of that, how many received the benefit of that. And then after an investigation, certain cases are closed, a certain percentage of them are closed. So I would like to the co-op would like to know, again, who's benefiting from that aspect of it, because we want to see, because we want to see, again, where, how can we avoid so much discipline, what communities are being impacted, and which lawyers are being impacted. And then we go to the settlement conference, of the early neutral evaluation. So again, how many people that I see as another off-ramp before you get to the notice of discipline or disciplinary action. So that's what I would really, really like to see. I think would be interested in that.
Got it.
And so I think there's another question though, Elizabeth.
Yeah, Judge Yu has a question.
Yes, so Ms. Lawrence, thank you so much. This is fascinating. I love learning more about it. I don't know if you know, but I spent 9 years on the Commission on Judicial Performance, where Greg Dresser is right now.
Great.
And I chaired that commission for about 3 years. So I know the CJP was sort of based on or actually was based on the State Bar's disciplinary procedures. So this has been great. Thank you.
Sure.
One potential off-ramp is not that it's really an off-ramp, but there are ways to help people, I think, such that the CJP started a mentoring program so that if a judge had a sustainable complaint of demeanor misconduct, the commission could decide to allow the judge to participate in a 2-year mentoring program and suspend the disciplinary proceeding to see if the judge would be able to correct that. And then because I was involved in starting that, I know that I had looked into other opportunities that other disciplinary bodies for judges used throughout the country that I don't know if they're off-ramps, but they could suspend the disciplinary proceeding to work with the individual and give them an opportunity to probably correct, or at least try to correct, the underlying issues, which the commission found would be very protective of the public. Because as you know, there are counties where there's only 2 judges or a small handful of judges. So the litigants don't really have a lot of options. And the only body that would know of complaints would be the commission. So working with judges, helping them have better skills benefited everybody, including the bench officer as well as the public. So I'm thinking of that when Judge Harben-Forte says off-ramp, I'm thinking, she's thinking of some of those types of examples.
Got it. I appreciate that.
Melanie, if I may?
Yes,
this is
absolutely.
Donna Hershkowitz. So Judge Yu, thank you for bringing that up because it triggered a couple of things. When we get to Dag McLeod and Ron B from our Office of Research and Institutional Accountability, Dag may talk a little bit about, and if he wasn't planning it, he will now, about proactive risk-based regulation, which is looking at certain, getting ahead of problems before they arise. I just want to let you know some other things that the bar is also rolling out in the next couple of years, things that we're working on right now that gets at that issue of really, trying to solve a problem before it leads to discipline. So one is we looked at a number of tools that other states provide, online self-assessments, where attorneys can take a look at the they take basically an online quiz and they learn about the sort of the things they don't know about. So it lets them know, hey, I probably need a little bit of help here in law office management. I don't really know what I need to know in client trust accounting. It's not, nobody's coming out and wagging their finger at them after they do it. It is providing them information so they can get the tools that they want. Also, Melanie mentioned we recently started capturing information on whether you're a solo, whether you work for a small firm. That used to be information that we only gathered based on report of a complainant who was making a complaint about a particular attorney, and we asked them, well, does this attorney work for by themselves, 2 to 11 people, bigger than 11 people? The size of the categories themselves is problematic, but the fact that you're asking the complainant, who really may have only dealt with that lawyer, is also problematic. But one of the reasons that we actually started doing that actually came out of a recommendation from OCTC, from Melanie's shop, because the thinking again is there is misfeasance, but maybe not malfeasance. In a lot of instances, and sometimes, there is absolutely this perception that we discipline more heavily people in small firms or solo practice than big firms. It may be because those folks have a lot more independent client contact. Those folks are the ones who are touching a client trust account. And so one of the things that we thought getting this information about type of firm would tell us is if somebody just switched from government to a solo practice or from a big law firm to a solo practice, they've likely never touched a client trust account in their life. And we want to make sure they know what the rules are. So the concept was we would learn of this switch to a solo practice, and we'd send out a congratulatory letter. Hey, congratulations, we see that you've just hung out your own shingle. That's fabulous. Let me point you to some resources that we have available on the State Bar website or our Client Trust Accounting School, some things that to provide you some information to help you in your practice. So those are the types of things that we're looking at, some preventative education, doing these assessments so people can understand where they may need to beef up their knowledge to avoid the misfeasance and not the malfeasance.
Okay, thanks, Donna. So in terms of other possible outcomes when it comes to discipline, obviously public reproval, and then the probation with actual suspension or stayed suspension. And so really, again, during this time period, there are conditions that the respondent attorney has to meet. Could be some of the things I already talked about, could be some other things like, for example, paying restitution if restitution is an issue. The period of actual suspension usually could be anywhere from 30 days upwards of 3 years. For the longer suspensions, anything usually 2 years or longer, the attorney is required to demonstrate rehabilitation to the court before actually being reinstated. And then at the extreme end is disbarment. There is not permanent disbarment in California. So after a period of 5 years, an attorney could petition for reinstatement. The attorney has to pass the bar examination, go through essentially a moral character examination, and the State Bar Court has to, and actually the Supreme Court has to eventually actually reinstate them, and there's a proceeding that we go through for that. Okay, also I wanted to let you know that the State Bar Court also has an alternative discipline program, and this is for respondent attorneys who suffer from substance abuse or mental health problems. The attorney has to demonstrate that they have a condition and that it causally contributed to the misconduct. And if they're able to do that, then what happens is the hearing department will essentially issue a high level of discipline or a low level of discipline. The idea being if the attorney is able to complete treatment, and this program is always going to require participation with the Lawyer's Assistance Program. There might be other conditions, for example, drug and alcohol testing, abstinence. But if the attorney is able to complete the program, they're going to get significant mitigation. And as a result, they'll get the low level of discipline at the conclusion of the program. And if not, then the high level of discipline will be imposed. So just to give you an idea of the other work that OCTC does, in addition to the complaints that we talked about that originate by clients or banks, etc., we do handle conviction referrals. This is when an attorney has been convicted of a crime. I'm going to talk a little bit more about that in just a minute because I know that you might have some interest in that area as well. But we also do reciprocal jurisdiction cases. That's when an attorney has been disciplined in another jurisdiction which they are barred, and then they are referred to us for disciplinary proceedings. Also, if an attorney is on probation or on a reproval period and they violate the conditions, we could bring an action to violate the probation or the reproval. It's actually a separate ethical violation in and of itself to not comply with the reproval. And then we also handle moral character cases. So when the Committee of Bar Examiners denies someone a positive moral character determination, that particular applicant can appeal to the State Bar Court. And in those cases, OCTC represents the Committee of Bar Examiners. And then also the reinstatement and mini reinstatement. These are the cases I referred to earlier. Reinstatement being if an attorney has been disbarred or resigned with charges pending, they have to go through a reinstatement process. And the mini reinstatement being that if they have been suspended for 2 or more years, having to demonstrate rehabilitation before they're able to practice again. Okay, so let's talk a little bit about convictions. So criminal convictions, like I said, are cases that we handle. They come to us, to our attention in a variety of different ways. So the District Attorney's Office does have to report by statute the pendency of any misdemeanor or felony case against an attorney. And also the courts are required by statute to report to OCTC the conviction of any crime of an attorney. Now, the challenge here is whether or not the district attorney or the court knows that the defendant is an attorney. And oftentimes they don't know, and so the reporting requirement is not triggered. But the attorney also has duties to report to our office certain misconduct, including if there is a bringing of an indictment or information charging a felony against the attorney. And then also if there is a conviction, essentially a conviction that was committed within the practice of law, where the crime was committed within the practice of law, or demonstrates dishonesty or moral turpitude, then they're required to report those to us. You may also have heard that the bar required everyone to be re-fingerprinted by the end of December 1st, or by December 1st, 2019. As a result, we have seen many folks who we were not aware of who had criminal convictions. And so we are working through those cases. I'm going to talk a little bit more about them in a moment. But I want to give you an idea of what we do with these cases, whether they come by way of the fingerprinting or any other kind of criminal conviction, is once OCTC gets the certified court records of a conviction, we have 30 days to transmit it to the review department. And so, you know, during that time period, it's a relatively short time period. I will tell you that not long ago, it was actually 5 days, and we were able to get a statutory change, thankfully, especially because of the fingerprinting effort. 5 days just really was not reasonable. So we now have 30 days, but you know, during this time period, some of the other things that we're trying to do is to actually get other relevant documents related to the conviction. So for example, police reports. We may be interviewing witnesses as well in this 30-day period. We actually end up also having to do it after the 30-day period, and I'll talk in a minute about why that is. But we do have 30 days to transmit it to the review department, which is where the criminal proceedings begin publicly. And then the review department, once they get it, depending on what the crime is, they will refer it to our trial level court for a hearing to determine whether or not the criminal conduct warrants discipline. So the question in any criminal conviction case first starts with, is the crime a felony conviction? And if so, essentially, if an element of the crime is an intent to deceive, defraud, something related to dishonesty, or if in the facts and circumstances of the crime itself, those amount to moral turpitude. And if the answer is yes on either one of these prongs, then the respondent attorney is subject to summary disbarment, meaning that there is no hearing. So it's the fact of the conviction alone. So it doesn't get referred to the hearing department for any kind of proceeding. There is briefing that goes on. The respondent attorney does have an opportunity to respond via paper. Then the review department is going to make a determination and transmit to the Supreme Court for summary disbarment. But if it doesn't fall into number one, then the next question is, if it's a misdemeanor, Does the conviction evidence moral turpitude in the facts and circumstances? So by way of example, if we have an individual who has been convicted of driving under the influence, but in the plea, and there were other charges charged along with the DUI, but because of the plea bargaining, some of those other charges were dismissed. We may still put on a case to determine whether or not the totality of the facts and circumstances amount to moral turpitude. So at the actual hearing, the question is not just for the court to look at what the crime was that they were actually convicted of, but all of the other facts and circumstances. So as I mentioned earlier, if there was a child endangerment charge, so there was something related to a young child being in the car, perhaps was traumatized or injured in some way, then the court may find that despite the fact that it's a lone DUI conviction, that the facts and circumstances amount to moral turpitude. If the facts and circumstances don't amount to moral turpitude, then the next question is there other misconduct warranting discipline? So by way of example, a second DUI conviction, the Supreme Court has said warrants discipline. And that's the N. Ray Kelly case from 1990. In that case, Ms. Kelly got a public reproval for her second DUI. The concern that the court had was the second DUI suggests that the individual perhaps has a substance abuse issue that could potentially bleed into their law practice and potentially harm clients. So, so this is what we're looking at the conviction stage. And in terms of what eventually happens in terms of the level of discipline, as I mentioned earlier, the standards will apply. So you see that there's summary disbarment. It could also be that even for a misdemeanor conviction, where the facts and circumstances amount to moral turpitude, that the respondent attorney could be subject to disbarment. And also, as I mentioned in N. Ray Kelly, there was a public reproval. So, related to the fingerprinting effort, to just give you a little bit of information about where we are with that. So far, 6,100 attorneys have been identified as having rap sheets, so having convictions on rap sheets. Now, I will tell you that that number does not necessarily represent the number of attorneys that we did not know about. And by that, I mean that obviously our office has been prosecuting these cases for years now. And so the fact that it appears on an attorney's record could simply mean that we did know about it. But of course, if it wasn't reported to us, if it didn't fall into one of the categories that we talked about earlier, or we didn't otherwise have information about it, it's possible that we didn't know about it and it hadn't been addressed. So we're sorting through how many of those attorneys are in fact attorneys that we did not know about. And for those that we did, then we are processing those. So just over 3,800 cases, not attorneys, but cases, have been transferred thus far to OCTC for further handling. And as I indicate here, most of those are still in process. And by that, I mean, we are gathering records, whether they're actually the certified court records. Just because we know about the conviction is not enough. We have to actually have the certified court records. And then we are evaluating to determine how to actually move them forward. And again, you know, collecting police records, anything that sort of fills in the story of the conviction itself. And in the process of transmitting them and resolving them, whether we're doing it by stipulation or by trial. So that's where we are with those cases. And that's what I have. I'm gonna, if there aren't any questions about the discipline process itself, I'm going to turn it over to the ORIA folks that are on the call to talk about where we are with Robertson. Well, actually, I just said that, and yet the first slide is mine. So this one is one of the resolutions that the board passed was that OCTC should not consider prior closed complaints that are 5 years old or more in determining whether or not to move forward a new complaint for investigations. So what we've done thus far on this one is I have sent out an email directive to all staff to cease considering any cases 5 years or older in determining whether or not to move forward with a new complaint. The challenge with that is that we have a case management system. It's called Odyssey. And currently in Odyssey, the reality is that the attorney evaluating the complaint can see the totality of the respondent's history. And so what we are working on doing is determining what options we have for archiving those complaints over 5 years old. And there are currently over 500,000 of those. And you can imagine that in terms of doing that manually, I mean, we will be here 2 years from now if that's the route we have to take. So we're looking at if there are programmatic solutions. So if there are ways to write some kind of script that will archive them, and it'll be a rolling archiving as cases age past 5 years. Okay, and now I'm going to turn it over to Araya.
Hi, this is Dag. I am the Chief of Mission Advancement and Accountability at the State Bar. The Office of Research and Institutional Accountability is within my shop. So I'm technically not Araya, but I have responsibility for oversight of Araya. Melanie, could you do me a favor and stop sharing your screen just so that we can, maybe I can see something. There we go, look at that. Lots of boxes of people. Yeah. So I just want to note that the director of Araya, Lisa Chavez, is on the line, as well as Ron B, I believe, is there. Although, did I see Ron? There you are, yep. So Lisa is the director of the Office of Research and Institutional Accountability. Ron is our principal analyst and does a lot of our data work. I think I wanted to back up a tiny bit. When we had heard about the request for information regarding this issue, we had heard about it in the context of the fingerprinting initiative. And so we did some preliminary work on the fingerprinting. And as Melanie noted, many of those cases are still sort of working their way through the process. So I don't know if it would be useful to back up and just remind everybody what the Farkas report said, the report that was presented to the Board of Trustees back in November, how the board responded to that, and the work that's been done since that, including the follow-up report that was conducted by a professor at Boston University who works in areas of implicit bias and has presented a report to the Board of Trustees. He presented it at the July meeting. Would that be a useful way to proceed, or is there something else you'd like to have me address?
I think that would be useful. I'm not sure if all of the COAF members had the opportunity to sit in on the board meeting or to review the report. So if you could provide an overview, that'd be helpful.
Yeah. So the bar has heard anecdotally for some time, in particular from solo practitioners and from non-white attorneys, that the discipline system has treated them unfairly. Until the November meeting, it was entirely anecdotal, and the November meeting was the presentation of a report at which the bar had taken the time and contracted with a professor at the University of California in Irvine to evaluate this, to really dig into the data and conduct a serious statistical analysis of whether we could find indications of bias in the discipline system. That report looked at the two most severe forms of discipline. That was the predictor, or the outcome variable that report was attempting to look at in terms of whether there was disproportionate impact. So that report looked at probation, attorneys who were given the second most severe form of discipline, probation, and attorneys who were given the most severe form of discipline, disbarment. And what the report found was that at the very first level, if you simply look at the proportion of attorneys who are attorneys of color and the discipline against them, and the proportion of attorneys who receive discipline, those two most severe forms of discipline, and the proportion of attorneys who are white, and the proportion of white attorneys who receive those most severe forms of discipline, you do see a disproportionate impact. You see that, and in particular, as Judge Harbin-Forte mentioned earlier, in particular for African-American male attorneys, there is a greater likelihood in terms of just your raw percentages of the percentage of attorneys in the profession and those who then get disbarred or placed on probation. There's a higher proportion of African-American male attorneys who are placed on probation or are disbarred. The next step in the analysis conducted by the professor from UC Irvine, Professor Farkas, however, then conducted what I think is typical in an analysis like this, conducted a multiple regression analysis, which is where you bring in other variables and you look at other factors that are potentially explanatory. When other factors were added into the model, what was interesting is that the race variable as a predictor of these outcomes actually disappeared in terms of its significance. If we were academics, we would be stuck kind of leaving it at that, because academics really are looking for statistical significance and trying to publish on the basis of statistical significance. And when a statistical significance disappears, it's no longer of interest. But this is not an academic exercise. This is a policy issue in terms of the fact that despite the covariates of race that accounted for these outcomes, the fact of the matter is that African-American attorneys, African-American men, are being disciplined at higher percentages than white attorneys. So what we did, rather than simply shelving the report and saying, see, no statistically significant effect here, is we looked at what those mechanisms were that were found in the statistical analysis. And what those mechanisms were that appeared to contribute to the disproportionality were these. African-American men receive more complaints against them. So just at the very point of intake of cases coming into the Office of Chief Trial Counsel, a greater number of complaints against an attorney, all other things being equal, is going to lead to a greater likelihood of being disciplined. You're simply opening the door to greater likelihood that something might be uncovered in your practice, that something may have been awry, that the Office of Chief Trial Counsel would not have been aware of had there not been a complaint to begin with. So this was one of the important factors that we found when we conducted the statistical analysis. And I say we, taking too much credit here because I did not conduct the statistical analysis. Office of Research and Institutional Accountability with the support of Professor Farkas. More complaints. Another factor that figured significantly in the statistical analysis was that African-American men were less likely to be represented by counsel during the disciplinary proceedings. So these two factors in particular, and then a third matter that wasn't found to contribute to the disproportionate probation and disbarment, but rather was a finding that was reported in the Farkas report earlier related to reportable action bank matters. As Melanie was talking about, there are various different paths by which cases come to OCTC's attention. The complaining witness cases where a client complains about an attorney are the most common, but a solid 2,000 or so cases per year on top of those 1,600 cases, 16,000 cases that Melanie pointed to earlier, another 2,000 or so cases come in through automated reporting. In this case, automated reporting related to client trust accounts. So when a client trust account is overdrawn, and the balance goes to negative, an automated report is generated that gets sent to OCTC. And they're on the high end of these cases where we found that attorneys had multiples of these. We found that it was more likely for there to be multiple of these cases against African-American men. So in looking to respond to the Farkas report and the findings, the Board of Trustees heard the report in November, directed staff to develop a response, and a preliminary evaluation of this was conducted between November and the January planning meeting of the Board of Trustees. The State Bar contracted with Professor Christopher Robertson. He's a professor of law, and his primary area has been looking at organizational behavior in the field of medicine, but has also, he's developing quite an expertise in terms of attorney discipline. He spent some time interviewing people in the Office of Chief Trial Counsel and understanding our processes in December, January, and then gave a preliminary presentation to the board in January, at which time they directed him to develop a set of recommendations and bring those recommendations back to the board in July. Before I talk about what Professor Robertson's report indicated and what his recommendations were, I thought maybe I'd pause for a moment and see if there are any questions related to where I've been, what I've discussed so far. I see Kristen Rossi. Is that how it's pronounced?
It's Rosie, but that's okay, Doug. Can you remind me, if my memory is correct, that the data that we were looking at in Professor Farkas's report only went to 2009, is that right?
Kind of. So the issue for a report like that, where you're looking at outcomes, is that you need a sufficient amount of follow-up time for to see whether something actually occurs. So the report included attorneys who were admitted to the bar between 1990 and 2009. So if you were admitted to the bar between 1990 and 2009, you would have been the data on you, if you had been disciplined or not, and if so, in what way, would have been included in the study. And then the discipline imposed on attorneys went from the period of 1990, so from that first date when attorneys were admitted to the bar who were included in the study, to 2018. So the 2009 ending for attorneys admitted to the bar is simply to allow for a solid like 9-10 years of follow-up post-admission to the bar, so that you're not looking at attorneys who were admitted between, say, after, say, 2015, and you've only got like 4 or 5 years of follow-up, and you're probably missing important information that might have occurred if you had a little longer follow-up.
Okay, thank you.
Sure. Okay, so I don't see any other hands raised. So I'm looking for both virtual and real hands. So, but I don't see any. So Professor Robertson spent a fair amount of time looking at different issues, looking at the issue of the representation and the lower levels of representation of African-American attorneys, looking at the question also of reportable action bank matters. Let me start with the reportable action bank matters. Professor Robertson hypothesized that there are these are one of the things that was puzzling about these is that they appear to have a rather race neutral sort of impact, like where we might imagine that there could be implicit bias that is informing a higher number of complaints against African-American attorneys. The reportable action bank matters on the face of it appear to be racially neutral. It's a matter of a client trust account falling below a zero balance. What Professor Robertson hypothesized was that the clients that African-American attorneys are serving and the cases that they're taking are likely to be of lower value are not, they're not engaging the corporate clients or the high rolling clients. Maybe they're even working with clients that are part of their own community who don't have as much wealth and whose cases involve lesser amounts and therefore involve client trust accounts that are smaller and have lower balances to begin with. And so his hypothesis was that when you're writing checks off of an account that has a lower average balance, other things being equal, you're gonna, you know, a simple miscalculation on like whether an incoming check has already like lodged and is in the balance, or writing an extra check, it makes a big difference in terms of your likelihood of actually bouncing a check or going into a negative balance. So Professor Robertson made a number of recommendations with regard to the way that the State Bar Court, the way that the Office of Chief Trial Counsel handles its evaluation of reportable action matters. He wants the State Bar to look into whether there should be a different de minimis closing amount. Typically, for reportable action bank matters where the bounce check is less than $50, and Melanie can correct me on this. When I say bounce check, I don't know if we're talking negative balance or bounce check, but she can give me the particulars on the, or clarify the particulars on this. But the issue is that there's a de minimis amount below $50 where Office of Chief Trial Counsel will typically close that case, maybe contact the attorney and say, hey, you need to be more careful. So the Board of Trustees wants the State Bar to look into whether that de minimis amount should be raised, whether there should be a higher de minimis amount that OCTC uses for closing cases. Professor Robinson also encouraged the State Bar to look into providing a sort of a more systems-based approach to looking at reportable action bank matters, rather than assuming that all attorneys are perfectly well prepared to be accountants to being attorneys, and in particular solo practitioners. Looking at the practice of law more in a systems approach, his analogy here, because he's worked a lot in the medical field, was to the way in which a surgeon isn't necessarily responsible for sterilizing the equipment. In fact, in many cases, shouldn't be responsible for sterilizing the equipment. That's something that other paid professionals are responsible for and can and should be responsible for. And he's interested in looking at the way that maybe the State Bar needs to think differently about how the different support pieces around the attorney work and who should be responsible for those. The other main area that Professor Robertson looked at was the area of representation, and there is no public defender system for the attorney discipline system. There's no equivalent to the public defender system. There's, as Melanie mentioned, there is an Attorney Discipline Defense Council association. They're the attorneys who specialize in this area of practice, and Professor Robertson spent some time with them talking about whether there might be a way of, there are sort of two prongs of this approach. One is to determine whether there might be a way of establishing a form of pro bono case evaluation, or reduced sliding scale cost representation for attorneys who might have trouble affording representation when they are facing potential discipline from the State Bar. We're following up and looking at that issue and trying to determine if there's a way that that can be done. We're also looking at how we message to attorneys the information that being represented makes a big difference in discipline matters. I think that there is possibly a sense among attorneys that as attorneys, when you're confronted with charges by the Chief Trial Counsel's office, you're an attorney, you can handle that. And because this is such a specialized area, and because we have seen in the data that it makes a big difference whether you're represented, we're looking at different forms of communication to inform attorneys early on in the process that if you are facing disciplinary charges or if you're being investigated, you should seriously consider getting counsel because your outcomes are likely to be better if you do. And then the final issue in terms of representation that we're looking at was simply whether self-help materials could be developed in the same way that many superior courts have self-help centers and materials to help improper litigants navigate the system. For those attorneys who choose not to get representation, we were looking at possible options for developing self-help materials for attorneys. I think I saw Judge Brenda Harmon Forte's hand raised there.
Yeah, yes, thank you. Couple of things. Are you looking at some slides? Should you be sharing your screen?
No, I'm
No,
not
you're
looking
not.
at slides.
Okay, okay, good. All right, then that's fine. I have another question that I should have raised it early on. When you indicated that there are more complaints against African American male attorneys or African American attorneys, did you factor in a couple of things that we know from studies we've done from COAF, and we're looking at the lack of diversity in the big firms. So many big firms don't have many African American male attorneys or many African American males at all. Typically, as well, the big firms may well handle their complaints in-house, so that if a client complains about something that an attorney did at the firm, that's likely to be handled basically in-house and not by the client making an actual complaint to the state bar. I don't know how you factor for that, but the mere fact that there are more complaints that come in against African American males, to the extent that you say it's race neutral or something, or you suggest that it may be race neutral, I'm not sure it is, because the reality is that there may well be the same number of complaints against a white lawyer, and had those complaints come to the state bar rather than being handled at the big law firm or being taken care of by the law firm's E&O carrier, you would probably have the same number of complaints. So I don't know how you factor that in, but I do think that we should be careful. And again, I've raised this before. It's like saying, there in terms of law enforcement and criminal contacts, that there are more encounters with the police, more African American encounters with the police. That doesn't necessarily mean that African Americans are committing more crimes or engaged in more criminal conduct. There are some other factors going on, implicit bias and other things that may well be going on. So I just think that we need to be careful in terms of
if I indicated that I thought that the complaints were race neutral, I apologize. I was trying to contrast the reportable action bank matters, which have a facially sort of neutral impact insofar as they're driven by an account balance. I was attempting to contrast those with the complaints, which I thought I suggested could potentially have an implicit bias related to that. And then beyond the implicit bias, I think the structural issue that you raise is critical. And we do know that African-American attorneys, or in particular African-American male attorneys, are more likely to be solo practitioners. And what you raise about the protective effects of, say, working within a large firm, we've certainly discussed that internally in terms of our understanding of like what's going on here. That there is, I think, I don't know how to refer to it other than a protective effect. That, yeah, it seems likely that a client is going to be more likely to complain to to one of the partners or to somebody within the firm rather than the state bar, should they have an issue with their attorney. We have, and final note on this is that we have data which we think is pretty inadequate, data on the complaints and whether the attorney is a solo practitioner or is a practitioner in a firm of between 2 to 10 attorneys or in a firm of greater than or equal to 11 attorneys. These categories of how large a firm were based on a legislative mandate from like 2000, where the bar was required to collect this data on firm size. But I say it's inadequate insofar as, first of all, these categories are kind of silly. Like 3 categories for firm size: solo, 2 to 10, and 11 and greater. That's problematic. Even more problematic is that the data come from the complaining witnesses. So how good a sense the complaining witnesses have of the size of the firm, of the attorney that they're working from, is pretty iffy. So this is one of the data elements that the State Bar has been working to try to improve and get from attorneys themselves rather than from complaining witnesses.
Well, perhaps you consider not using prior complaints at all as any factor. Just don't look, I mean, if you just look at perhaps whatever one complaint you're dealing with right now to assess that.
I'm so glad that you mentioned that. So as I indicated at the outset, we were alerted to this meeting by way of the interest in the fingerprinting data. So the reason why you didn't see my slides is that I didn't prepare any slides. So I thought that we might be talking about the fingerprinting matter. So
yeah, we will.
This is a slightly extemporaneous riff off of the various different pieces of work that we've been doing lately. But the final piece that I failed to mention because of the extemporaneous nature of my riff was that the prior complaints were looked at by Professor Robertson as well. And this is actually, and I apologize for not mentioning it because it's a pretty big issue that we're looking at right now with regard to prior complaints. And that's looking at shielding prior complaints from investigating attorneys and from intake attorneys so that when a complaint comes in, complaints that are older than 5 years are effectively archived and are not immediately available to the attorneys in intake, and that a process is established that creates some presumption of absolute need for really looking at those complaints, those prior complaints, rather than allowing them to simply be available to the attorney at first glance if you were to call up the record and say, oh, look at this, all these prior complaints. So the prior complaints was also addressed by Professor Robertson, and is something that's being evaluated right now in terms of how we were going to do that technically and shield those cases, archive them, place them outside of the view of the attorneys in intake when they first evaluate a case. Melanie, do you have anything to add to this on the prior complaints?
No.
Okay.
And one final question: the prior complaint, they don't have to have been actually have been sustained or found to be true. You just look at the raw number of whether or not there were prior complaints. You don't look at actually factually sufficient complaint. You just say, all right, 10 clients or whatever complained about this lawyer in the past, and all of those complaints could well have been just, I'm pissed at my lawyer today, so I'm gonna, or I got convicted, and so I'm gonna complain because I want to blame my lawyer. So okay, all right, I'm done. I'm done. Thank you.
So
thank you.
Melanie, hang on, Doug, 1 second. Melanie, do you want to address that point a little bit? Because I think that I'm glad to say that is an oversimplification, that there really is a focus on legitimacy of the complaints, or whether, the relationship to the current complaint, or whether there is whether the complaint establishes a pattern and practice. But Melanie can talk to it a lot better than I can.
Sure. Well, I mean, I think this came up in particular for Professor Robertson because in talking with our staff and trying to figure out sort of how a complaint history is evaluated when looking at new complaints, I think there was some concern that in cases where it wasn't entirely clear on the four corners, which I had talked about earlier, that there was sufficient information, that there was a concern that staff may be going back and looking at the complaint history. It's not necessarily just the sheer number of them, but they would potentially look at the substance of the complaint and to determine whether or not there was similarity in the allegations for purposes of potentially moving it forward. And so I think that's why, one of the reasons why Professor Robertson was suggesting that we essentially archive those complaints so that there isn't sort of pattern looking. Now, I mean, the reality is that it does come up at times that there are patterns in complaint histories, but that are real, that we should be looking at. But sort of like the example that you gave, I mean, the fact of the matter is, even depending on what the practice area is, there are certain practice areas where we know there are a larger number of complaints. If you're a criminal defense attorney, for example, or if you are a family law attorney, those folks oftentimes get a lot more complaints, and they're not necessarily, you know, sustainable on any level.
Thank you both. All right. Go ahead, Dag. I didn't mean to interrupt. I'm done.
I would open it to questions.
Dag, this is Kristen. I have a question, and maybe Melanie knows the answer. When Ryan and I met with Dr. Robertson, he indicated that a large number of these reportable action cases would go away if we raise the number to say $500. Do you have a number or percentage of how many of those would go away if we raise that reportable amount?
We do have a preliminary number. What we've seen in looking at the amounts in the balances of historical reportable action cases is that it is about half of the cases would go away if the de minimis amount were raised to about $500. We also have done some preliminary analysis of the data, though, and have found that unlike what we were thinking, which was that as the amount increases, the likelihood that there was actual malfeasance involved, to the extent that we can measure that, measured by whether the person ultimately received discipline, it has a sort of strange relationship to the amount. And when you get to the much higher amounts, that's not where we seem to be seeing the greater likelihood of discipline. So there may be some public protection implications here, in that both the number of reportable action bank matters that an attorney receives, and sometimes in that lower range before you hit the $500 amount, those seem to be predictive of future discipline. So we're noodling that, as they say, and trying to understand what the implications are for public protection here.
Is the predictive discipline that you're seeing more reportable bank actions, or is it other types of discipline that are maybe less?
It's all forms of discipline, but as predicted by the reportable action bank matters. So in many cases, I think it is related, but you have to really dig into the actual discipline and look at the orders to determine, like, what were the allegations, what was sustained, what was the issue on which the attorney was ultimately convicted.
Okay.
Dag, I have a question. So there was a theory advanced that the investigator and the prosecutor's knowledge of multiple prior complaints might influence more aggressive prosecution, and the suggestion was to shield visibility of the prior complaints and only focus on the complaint at issue. Is that recommendation being implemented?
Yes, it is.
All right, thank you.
I suppose that if there are no further questions or anything else to present, what I want to do, are we going to hear from Ron, though, right? Does Ron have, no? Okay. All right, great. Then I want to thank you all for presenting, for having this discussion, presenting the information, and thank you, Melanie, thank you, Dag, and thank you, Ron, for being there on deck to give us anything we needed. I want to make sure that council members don't have any questions about anything, but I don't. Elizabeth would alert me if anyone had raised their hands. So I think that we are done with you. We're done with you, Dag. We're done with you, Melanie. But again, Yeah, thank you so very much. And if we can get any of those statistics, Melanie, that you indicated, I think that would help COAF a lot as we try to understand the question and as we understand the issues so that we can make some appropriate recommendations to the State Bar Board of Trustees about perhaps what action can be taken.
I think we welcome the opportunity to come back to COAF at your next meeting and discuss. And I wanted to also just congratulate you on your tenure as the the pioneer of the COAF work, and congratulations on whatever you plan to do next.
Thank you very much. I'm still not retired. I still tell people I'm a rhino. I'm a retiree in name only. So I'm on this, that, including the Oakland Police Commission. Our meeting last night went until 12 o'clock. Started at 6:30, went till 12 o'clock. And I'll be joining the Jenny Commission in January. My term will begin. So I will be very, very
You haven't
busy.
seen the last of me because Jenny's in my shop. So I look forward to seeing you around there.
Well, thank you. And we go back to Alameda County Superior Court. So we have a long history. But thank you. And again, Melanie, thank you so very much for everything. This was very educational. And I just want to point out, as Erica, Judge Yu has already pointed out, she's going to be a great asset on COAF as well because of her experience with the judicial discipline system. So she's going to have some great ideas and good input as well as the liaison. And she is, Thank you all very much. Okay, thanks.
Thank you.
All right, so we are, let's see, should we, so next we have Banafsheh, correct? Banafsheh is coming up now?
She was gonna come at noon. So do we want to take a break and come back at noon? But I want to ask Lisa Chavez, because she's also, if she's would be available to circle back on the on the diversity report card, because she's presenting on that since we're on the schedule.
Okay,
yes,
well,
absolutely.
Okay, so maybe we should take a 10-minute break.
Yeah.
And get some more coffee and water, and then convene for Banafsheh since she's scheduled at noon. Is that okay?
Yes, that is perfect, and we're going to go until about 12:30 with her, and then we'll probably take about a lunch break about 12:30 or so.
Okay.
All right, that's perfect.
Okay, thank you.
Right. We shall stand in recess.
Hi, Judge Brenda. It's noon now, so and I see Banafsheh has joined us.
All right, then we will go back in session. All right, hi, Banafsheh.
Hello, Judge Brenda. Hello, everyone.
So Banafsheh is the chair of the Legal Services Trust Fund Corporation, and she's going to talk with us a little bit about things that we can perhaps do, discussion of issues related to entry into and retention and advancement of diverse attorneys in the legal services nonprofit sector, and and things that we might be able to work on COAF and the Legal Services Trust Fund Corporation. And you have a staff person as well, Dwan. Hi.
Hi.
All right.
Good afternoon, everyone.
Good afternoon. So let's go. Banafsha, take it away.
Well, I was hoping that we would co-collaborate in this conversation. First of all, I want to thank all of you for inviting me and allowing the Commission's voice to be heard here. We are looking forward to you all coming and joining us in November at the Commission meeting that we have. And really the objective is at least from our point, and I think Judge Brenda and Judge Esther also have the same viewpoint with Dwan and Elizabeth, is to figure out how we could manage working together. We were in the same office. We're really the other side of the same coin, and we're working on a lot of the same initiatives. And so how could we pool our best thinking and resources and make the greatest impact, especially right now. So from what we see, as Judge Brenda mentioned, we're looking at access and we're looking at retention, and specifically in the nonprofit legal services community, we fund about 100 different legal aid organizations up and down the state of California, which you guys probably know a little bit about that. And so what we've been seeing is, the salary levels tend to be on the lower side. The lawyers that are drawn to the work tend to be people of color. And the retention seems to be really an issue to keep these folks active and involved in this good work. And I know that on the COAF side, you all are looking at the same types of issues, in particular pipeline and how to be able to move lawyers into such seats, into doing this kind of work. So that naturally became a conversation point for Judge Brenda, Judge Esther, myself, Dwan, and Elizabeth. And so what I was hoping for is to engage you all to hear what's happening from your vantage point. And as I said, for you guys to come and join us at the Commission and to hear then from our vantage point. And this would become the initial stages of hopefully an impactful partnership and collaboration.
Great. Banafsha, I'm going to ask you, for the benefit of those who don't have a lot of information about the Legal Services Trust Fund Commission. Can you just give, it is a state bar sub entity, but what is your mission and what's your goal? Just a quick overview.
Yeah, I'm actually going to ask Dwan to jump in and Elizabeth to jump in as well, so that the three of us are sharing out. I want the ladies to not feel like they need to be in the background. So Dwan, why don't you take it away with the question?
Sure. So the main objective goal of the Trust Fund Commission is they're their oversight body for the legal aid grants that go out through the state bar. The most notable two grants that we distribute to legal aid organizations are the Interest on Lawyer Trust Account grants, IOLTA grants, and the Equal Access Fund grants. With IOLTA accounts, as you all may know, that attorneys are required to put into short-term IOLTA accounts or accounts that are nominal in amounts, and then by statute, that revenue stream is provided to the state bar, and we distribute it out as legal aid grants. So we're governed by the Business and Professions Code. It's a very kind of specific requirement in order to qualify for the IOLTA grant, and the primary purpose of an organization has to be to provide free legal services to indigent clients in California. And there's a really specific definition of indigency, and that's a client that's below 125% federal poverty. a senior or a person with a developmental disability. So that's really like our banner grant. We also have a contract with the Judicial Council to administer the Equal Access Fund grants. So that's been ongoing for over 2 decades now. Through budget trailer language, the EF grants, 90% of the EF grants go out similarly as the IELTS grants. And then there's another 10% grant, 10% of the EF that goes out through partnership, which are partnerships between the courts and legal aid organizations to provide self-help information and assistance to pro se clients. And in the last few years, luckily, we've been the recipient of other discretionary forms of money. About 5-6 years ago, through the kind of mortgage foreclosure crisis, we received a portion of the Citibank and Bank of America settlement, about $50 million. Last year, because of the homelessness prevention crisis, the legislature carved out an additional $20 million to go out for homelessness prevention. And just this past June, the legislature, not the legislature, but part of the national mortgage settlement, we received another $31 million to kind of tackle this kind of eviction crisis that's coming upon us. So the Legal Service Trust Fund Commission, they are tasked, the responsibility is to distribute this. Unfortunately, 2020 was a banner year for us with the rising interest rates of close to, I believe, over $80 million. But unfortunately, with the shelter in place orders and the pandemic, the interest rates have plummeted, and IOLTA interest, our IOLTA revenue stream has taken a significant hit. And for 2021, the distribution for IOLTA grants is dropping by 57%. For our programs, and another 11% on the EF side, because part of the EF is filing fees, and with the court closures, it's really taken a big hit. You know, luckily we have some money for the eviction work, but it's not going to be quite enough now that we are kind of in crisis mode. So the commission not only provides the oversight for the grants, but you know, the commission and staff, we provide a lot of legal technical assistance to programs to support them kind of through these difficult times. So that's kind of the overview.
Yeah, and if I may add, just so that everybody has context. So our office, the Office of Access and Inclusion, we are charged with, you know, implementing the Access to Justice and Diversity and Inclusion initiatives of the State Bar, supporting the Legal Services Trust Fund Commission, as well as COAF. And so our staff, a lot of the staff that you all work with, we all, including Dawn and I, we all have diverse portfolios. So we all do some grants administration as well as support the diversity and inclusion initiatives. So that's how the staff side is intertwined. And really the thought in housing these two areas of work together is so that the work that we're doing, in access to justice and diversity and inclusion could inform the grant making to the extent possible, and vice versa.
All right, thank you. I wanted to have Madam Sheikh come again so that we can talk about the overlap between what COAF needs to do and is trying to do, and what Madam Sheikh's needs are, and particularly in the legal services nonprofit sector. We also need to look at the diversity aspect of it and pipeline issues as well. If we don't get diverse attorneys through law school and passing the bar and out into the field, and we are not likely to have enough attorneys at all to handle the legal services nonprofit sector, and certainly not enough diverse attorneys, because much of your work is done with communities of color. Much of the work is done in communities of color. So we wanted to talk about also some pipeline issues and to see if there are things that perhaps we can look at in terms of what may well be needed along the pipeline now that COAF's work can extend down to the high school level. We can talk about things that we perhaps can do together or recommend that others do to increase the diversity of the legal profession. So if I'd certainly be interested. This is a discussion aspect, so I'd really be interested in seeing if any of the other members of COAF have any questions or any suggestions. Or Banisha, is there anything else that you want to add or talk about right now?
Yeah, you know, the what both Dwan and Elizabeth spoke to, I think that I'd like to highlight or underscore. One is, you know, funding is in the pipeline for certain issues, important issues like eviction and homelessness. But these groups are potentially going to be hit hard financially in 2021, 2022 as we go forward. So thinking through what are the best ways to be able to use the resources we have, both from the COAF side and the commission side, would be ideal. And then, you know, really understanding how these two, the commission and COAF, have come together in the office, and you know, staff works so hard, as you guys know. The hours that they're putting in are extraordinary. And how to not, my goal is that we don't make more work for them. And every time I come up with an idea, I feel like I'm making more work for them. So I want to be conscious of that as well. So yeah, and then to hear from the rest of the group here, what are some of the issues that you guys are seeing? And I'd love to just hear your vantage point on the matter.
And I will say that we have received the Justice Gap study. We know that one of the reasons we don't get a lot of people into the legal services area is that so many people graduating law school with such high debt. We learned that people come out with hundreds of thousands of dollars in debt. So they are looking for enough income to pay off that debt. And because the salaries are so low in the legal services arena, many of them can't afford to take those jobs or to stay very long if they initially go into the legal services or nonprofit sector.
That's right.
So I'm not sure what we can do to increase the diversity there. But I'm certain I'd like to hear from any other members of COAF as well who may have some thoughts or questions or concerns.
And just to add, Judge Brenda, one of the findings that came out of the Justice Gap study, that's not surprising to any of us, but you know, with the public interest attorneys at the executive level, it is less diverse than the kind of aligned staff. So that's also something to keep in mind, that we want to build the leadership pool of more diverse attorneys to take on kind of the executive level and managing level.
Okay.
And Judge, you has a hand raised.
Thank you. So I know that VABank, the Vietnamese American Bar Association in Northern California, gives significant stipends or scholarships to young Vietnamese American or Asian American lawyers who are willing to serve in legal services. So there might be something that the State Bar, in partnership with the minority bar associations, can do to support people, because the debt is high and those jobs don't always pay, you know, the same. And so there might be ways to encourage and open doors.
It's a great idea. There's been some discussion about that. That's a great idea. I think we've had some questions.
I also just wanted to add one other piece of information is that that we're working on a diversity summit. You know, as you know, in the past, this would be the third year, we've had diversity summits kind of engaging with the legal profession as a whole. But this year, because of the data that we are seeing in the diversity report card, as well as feedback that we've gotten from past participants, we're having sector-specific summits. So we will have our private sector summit in September, and then we will be following up with a nonprofit focused summit in December. So this is very timely, and I want to just, you know, stress that it's just the beginning of a conversation. So I just wanted to add that piece of information. But I know Sarah has a comment. So
yes, and Elizabeth, we're fine. we're fine. We will take comment and discussion from anyone, even though they're not formally yet COAF members.
Yes.
Sarah, okay,
Okay,
very good.
sure,
So, all right,
sure.
so Sarah, you have the floor.
Okay, Judge Brenda, I'll follow everybody else's lead on that. I love that. So I just was going to say, with respect to high school sort of pipeline programs, my firm since 2007 has had a pipeline program for 5 rising seniors in the San Francisco Bay Area schools to come to the firm and spend a summer. They do a mock trial, they go and visit a client, typically a high-tech client, and kind of see what that's all about and what working in-house is all about. There's a programmatic aspect where we help them on their college applications. They get to see kind of the work of the firm, and they work in different parts of the firm, both legal as well as running the business of the firm, finance, client services, you name it. And there we hire 2 people directly through our application process. We also typically take 2 people from Balboa High School's Law Academy, and then also somebody typically from Enterprise for Youth in the Bay Area, to round it out to be 5. Unfortunately, for obvious reasons, we couldn't do it this summer, which was really disappointing. But since everybody's remote, it just wasn't feasible. But certainly that kind of program, which I know when we created it, it was then copycatted by some other firms that have done it. And I know that BASF is also involved in that as well. So that's a very good program, I think, for people to kind of look to, at least in terms of pipeline in the private sector. We've had, one pipeline alum graduated from college, came back and worked with us as a paralegal, and she's off to the University of Michigan Law School this fall. So, we feel pretty strongly about it, and it's kind of really important to what we do. We also offer 3 scholarships, to the money point, Judge Brenda, 3 scholarships to 3 1Ls, typically from Bay Area law schools, of $10,000 each. Drop in the bucket relative to the overall price tag, but still helpful. And I know many, many other private law firms these days are offering similar type scholarships. Ours doesn't come with a commitment to have to come to the firm and work. You automatically have a callback interview if you want to be a summer associate, but we often give the scholarships to people who are interested in public service, government, nonprofit. Runs the gamut. We're not just looking for people who are interested in the private sector. So anyway, I just wanted to kind of throw that in. There's a lot of stuff out there on pipeline programs that might be of interest, and I'm happy to give more detailed information than that.
All right. Thank you, Sarah.
May I just ask really quick, Sarah, which firm are you with?
Farella, Braun and Martel in San Francisco. It's about 130 attorneys, so a mid-sized firm.
It's great. And then are you working with other firms to kind of model what you just discussed?
We did in the early days. I believe, well, I don't want to name names because I might be wrong and this is recorded, but there are a couple of firms that have copycatted it and are doing it as well, which is great. And I know that BASF, also the JDC, has picked this up as well. So, right now we're more focused on just running our own program for the summer because it does require, a lot of work, obviously.
Right.
Great.
So maybe, do we?
Hand raise, I'm sorry.
All right, go ahead. Go ahead, Heather.
Okay. I was just going to echo what Judge Brenda said. I think, the pipelining issue is really super influenced by the money issue and the tuition concern. I'm in-house and I butt against the opposite in that we too need diversity and so are constantly emphasizing pipelining efforts, and the reaction we're always getting from young people in law school is that they want to be doing this work. They want to be in public interest. They want to be in civil rights work. And so we're trying to convince them, to come in-house and do that work via pro bono efforts. but and even though we have that financial incentive, they still are very driven by the work that they want to do, but they're trying to balance that interest out with the financial portions of it. So I'm so grateful that the firms are providing the scholarships, but certainly loan forgiveness, you know, pushing for those programs now more than ever with all the social injustice. I know they're out there and they exist, but maybe they need to be, you know, built up even more with all of the things that we're trying to address right now. So having the lenders kind of get more involved in that space might be helpful, because certainly it's not for lack of interest from a diverse community of law students. It's really the financial hindrance of it all.
Very
and I just
good.
also wanted to add that in the Justice Gap study, we did find that you know, student loan debt load and other kind of financial you know, responsibilities for students really drives where they eventually want to find employment. And so we looked at public interest drift, where, you know, what you enter law school thinking, you know, I'm going to become a legal aid attorney and really help out my community, but then you realize I can't do that because I have hundreds of $1,000s in debt and will need to support, you know, my parents or my family members. And so one of the things that the Justice Gap study also found was that when a law student has a legal aid internship during law school, they are more likely to go into legal aid after when they graduate. And so one of the recommendations is for us to look at whether funding those positions would you know, help that pipeline issue. We've kind of pressed pause on it because of the pandemic and just what is happening with our grant revenue through the IOLTA revenue, but that is a priority that we will be turning back to, you know, as we get back to this new normal.
Yeah, and you know, and the issues that we're discussing, you know, I think really more than before the pandemic, we need lawyers, we need legal aid attorneys, we need pro bono attorneys, we need hands on deck. You know, some of the organizations that we fund have come to us and have shared that the number of cases and calls that they're receiving in the first quarter, second quarter of this year is more than they have seen in all of the years prior. So, you know, and this is in the employment sector, it's in the housing sector, it's in immigration, it's across the board of all of the areas in which we fund. So, you know, all these efforts of law firms coming forward with pro bono help, finding access to the different race-based or immigrant-based legal associations. I'm part of the Iranian American Law Association. So having access to some of these hands, I think, is also as important as finding ways to retain and maintain those that are in the seats that are currently there. And I think what Dwan mentioned, and I don't want it to get lost, you know, as you know from your vantage point, those leadership seats aren't necessarily a representative of the communities that are being served. And so finding ways to be able to grow and develop and train those individuals into those leadership seats are also as critical, I think, because then obviously those organizations start to resemble the communities here in the United States, here in California, and they have a natural pull in terms of how they're hiring as well.
Okay. All right. Thank you. Any other thoughts or comments or questions? Again, this is the beginning. This is the beginning of a discussion, and we will certainly have more discussions.
Judge Brenda, I think we have someone who's would like to say.
Yeah.
Okay, go ahead.
I just thank you, Judge Brenda. Thanks, Elizabeth. I just wanted to actually piggyback on something that Heather just said, which and maybe Judge Esther, this is something we can think about in the year or so to come. And that is that now also seems like a great time to be reaching out to financial institutions, and especially ones that are California based, you know, whether it's Wells Fargo or whether it's Bank of America, and really encouraging financial institutions to do more of their own loan forgiveness. As somebody who spent 25 years plus now in public sector and tried to apply for the federal loan forgiveness program for lawyers, it's impossible. It's impossible to get, even for somebody who spent their entire career in, public service. Everyone's application is getting rejected and it's impossible to meet. And maybe we need to start thinking about it from a California local standpoint and getting financial institutions on board and having their own, forgiveness programs for the ones that are handing out loans. You make a lifelong customer if you're Bank of America and you give me a student loan and you forgive portions of it later. If I go into public sector, I'm probably more likely to bank with you and get my mortgage with you. Maybe that's an avenue where we can address this gap in, and I mean, many of us went to law school when it was a lot more affordable. And, I'm still paying my student loans off, more than 25 years later. So.
Yeah, as someone who spent a lot of time in the public sector myself, there's no way to, it seems like, to have those loans forgiven. I know that what they gave to us in documents in the financial aid office isn't actually what is happening after the fact. But what you're picking back off of what Heather was speaking to, I think, Dwan and Elizabeth, this might be something for us to look at because we have relationships that we've built with banks, right? So this might be a conversation that we could start to explore and see if there's an avenue here. Obviously, needing a lot of backing, legislative backing potentially, and people in the community. But I think there might be something that we could start to explore and see what's possible. And as Judge Brenda said, this is the beginning, hopefully, of a strong partnership between COAF and the Commission as we go forward during these troubled times.
And go ahead.
We have a request for public comment by Will Pichelli, who's actually a Legal Services Trust Fund Commission member.
Okay. All right. Great.
So Will, I've unmuted you, so I think we can hear you.
Okay. All right. Thank you. And thanks for just the time and all the work. Hi, Banashef.
Welcome.
I just wanted to add briefly, because this was such an interesting conversation to me, that one of the ways I think this council could consider addressing the pipeline issue is to really take into account the paralegal and maybe eventually paraprofessional system. I know, having gone through a paralegal program, that there was a lot more diversity at the community college level than I see elsewhere. And having had those conversations, I know the major obstacle is money for the people who had the passion, because I would look at it as, oh, I would love to get that JD and pass the bar and all of that. And then $200,000 in debt later, I need to work for the people who can pay me. And I'm sure that all of you are aware of that. But I wanted to add just that point on the pipeline, that I think paralegals and paraprofessionals and people with passion sometimes choose that path, and giving them, that's an opportunity to give them more information on how they can up their game and get that JD. Thank you.
Thank you. Thank you. I'm just thinking here, wouldn't it be ideal if some of the private lenders would have a loan forgiveness program in exchange for working 3, 4, 5 years or something at a legal services agency? That would be wonderful. You don't have to pay the loan back, but you got to go and you got to take this. You have to take this job at legal services, at legal aid or other nonprofit, and we'll give you so much credit toward your loan for each year that you're there, with a minimum of at least 3 years, 5 years. I'm not sure, but I'm just thinking off the top of my head now.
Well, but Judge Brenda, that was actually the structure for if you were in the public sector and there was a, you know, a variety of different ways to serve, that you would have your loan forgiven after a period of time. That has, it's kind of either been suspended or it's gone away, but the model exists. And so it would be, we could use that model and the conversations with some of these lenders if they're up for it.
Yeah, and we don't know, I mean, legal, you know, OGC would have to weigh in terms of what kind of deals we could cut with Bank of America, Wells Fargo, and others. But that certainly could be the model to use. And if the loan, as you say, if it's through a private lending institution and they have the flexibility to do that, it would be a great way to encourage entry into the legal services field and the service there. All right. Okay, great. I'm sorry.
Heather has a comment.
Okay.
Yeah, I just want to jump and reinforce everything everyone is saying, which is too, I mean, the financial institutions could also do full ride scholarships for law students tracking into these programs at the law schools. You know, UCLA has a program that is public interest specific, so they could hit it from both sides. But I really want to emphasize that time is of the essence. And we all know with government, like this could take a long time, but these corporations are making their strategies in reaction to social injustice right now. And if you want this money, you have to get into these conversations before they're allocated someplace else. So I think at least getting it on the right, you know, companies' radars so that they're thinking about it and putting it into their strategic plan for the next, you know, year and coming up into fiscal year or two is really important, even if you haven't figured out all the details yet, but really getting in front of this quickly. This is the topic du jour. So we should take advantage of it.
All right. Let me ask Elizabeth. So our next meeting, the next COAF meeting is not until December, right?
That's right.
And should we try to get some kind of work group? Can we do a joint work group with?
So in terms of reaching out to banks, our office does work a lot with banks because we manage the IELTS bank compliance. So the interest, they remit to the interest on the IELTS accounts to us either monthly or quarterly. So we are working with them constantly. And so our big goal right now is to make sure that they are remitting at levels that are comparable to what the private accounts are earning on their accounts. So I think, you know, as a staff, we would probably have to circle back to see what our strategy is, because we are making very big asks of them right now for them to keep their interest rates up. And we'd need to figure out like who, you know, we're dealing with people who are, you know, managing the IELTS account. So we would need to figure out like, you know, what department deals with loan products and that sort of thing. So maybe if staff can, you know, have some time to figure out what a plan would be, then we can circle back before December with a little bit more information.
Judge, can I make a comment? Oh, sorry.
Yes. Yes, go ahead.
I think this conversation is really fascinating, intriguing. The other thing that I think has been floated around for some time now is, you know, we're part of a larger legal community, right? Sarah's part of a law firm, Heather's part of corporate in-house at Disney, and so, you know, there might be more, I guess, attractive pressure points if we can go through that route as well, because you know, as part of a large law firm or mid-sized law firm or corporation, you also are banking at financial institutions. And so maybe as a client, they may be more persuaded from that angle. Just a thought.
Okay.
And that's what I was just speaking to earlier, and Duan was much more eloquent, that yes, it's going to take a community effort on the legislative front, like I was mentioning, the community, and then of course, large firms and corporations. You know, I'm also wondering, Elizabeth, as you were saying, you know, there's the IELTA division, and we're looking at potentially the student loan division, but I also wonder if there's a community kind of foundation division and then a DNI division, because this kind of crosses over so many different areas, and they could, you know, they could really hit a home run, right? With a number of.
Yeah, you're absolutely right, Bonafide. When we talk with the banks and try to negotiate their interest rates with us on their IOLTA accounts, sometimes we are dealing with their community. Can't remember their exact titles, but the side of the banks that are looking at investing in the community or other departments. A lot of times we're dealing with just transactional folks. So yeah, it does vary from bank to bank, much like I think law firm giving.
Yeah, like the community development, and I think we have someone else that.
Yeah, and so I think Jose has a comment and Heather has a comment.
Okay. Hi, thank you. Yeah, I just wanted to comment on the relationships with the banks. As maybe some of you know, we've done a lot of programs out of our office connecting low income and unbanked folks to bank accounts and safer financial practices. We've maintained a good working relationship with the banks over the years. We actually in our office undertook a survey of our banks here in San Francisco to see what kind of practices they might be able to extend people during the pandemic. In other words, maybe forgiving overdraft fees, allowing some flexibility on repayment terms, and things like that. We've actually produced a report and published it recently that looks at what the handful of banks that did respond to our survey are doing, and we're obviously going to keep this dialogue going. I'd be happy to share that report with you all. Elizabeth, maybe I could send it to you. Yes. And I'd be happy to work with anybody who's in dialogue with the banks. We talk about these kinds of matters with, obviously, financial institutions.
And Jose, thank you. And let me let everybody know that Jose is our Board of Trustees liaison, one of the two COAF. So thank you. And when you say your office, how about telling everybody what that office is?
Oh, sorry about that. Yes, I'm the treasurer of the City and County of San Francisco. Thank you, Judge.
All right, no problem. All right, well, thank you. And thank you for being here and for your input. Let me, so my question, oh, I'm sorry, was there another comment after Jose?
Heather? It was me, but I was going to say the same thing about going the D&I and community outreach route instead of just the financial services route. I think that's the entree into that team to take a look into this. And Judge Kristen's point about like you're creating the investment in the community with, people who might then bank with you or get mortgages and stuff. I mean, this is really emphasizing this is the investment into the community for them. Again, while this is the hot topic, I think is
and I think Heather's right that this is the time to do it, right? Right now is the time to be making the ask because of the momentum and because, these are social justice issues are right in front. And, we do need to strike, I think.
And we're thinking about the big banks, but don't forget about your credit unions too, for the ones that are associated with all the places we work. So.
Great. Great. Let me ask this. Although staff has to do some work for sure. But should we try perhaps, and Elizabeth, you and Dawn can tell us can we do like a joint work group with Legal Services Trust Fund Corporation and COAF, where we just over the next few months, we sort of look at what kinds of ideas we might be able to come up with again, we got to get people into the pipeline and into legal services, into the legal services arena. We need lawyers there and lawyers who can afford to make a long-term commitment and perhaps stay there long enough to get into upper management and be in leadership positions as well. So is it possible? I don't know if it's been done before, if it can be, but we are two sub-entities. Can we sort of do like a joint work group? And perhaps the membership, let's see, Bonafide, your next meeting is in November?
On the 13th of November. And because of all of the additional work that's before us, there's the potential of having additional meetings, like ad hoc meetings. So if that were the case sooner than November, and you all are agile and ready, we could incorporate you into that meeting.
Okay, I'm kind of wondering if maybe we could try a work group, and we won't, it's going to take some time to get some things done, but I mean, why not now at least appoint somebody if we have volunteers? And then Bonafide, we'd need someone from your group.
Well,
And
actually, there are a couple of folks that have come to mind. And Judge Brenda, I think we just made more work for the staff, exactly what I was hoping not to do. But here we are. But,
yes, but Elizabeth said that they would have to do some things. I mean, they would have to check on some things.
Yeah,
I mean, we could do it two ways. We can wait and do it, but if we wait, we may miss.
I agree with Heather and Kristen that the opportunity is now, because it's the issue du jour, and our communities need it now more than ever. So, you know, the serendipity is that it's happening at the same time, right? The need is there for them, those that can do, to look good and to be part of the right conversation, and those that need to be able to receive. So if there's a way in which we can do that, and I'm also really mindful of the calendar that Duan keeps creating for us, and how much is on that workload. So maybe what we could do is, Judge Brenda and Judge Esther, we could have a kind of a sidebar and do a smaller group, now that we know potentially that this could be an issue that both the groups could work towards, and massage out what those details might be, and come back and report out. But I really want to make sure that you guys come to the commission meeting, one or two of you, and we could continue this bridge of dialogue. I think it's not only healthy, but it's necessary. And I'm excited that we're able to do this. I don't think this has been done before. So that too is something that we need to kind of figure out and navigate. But it's exciting to be able to work together.
So let's I'm sorry. So let's do this, because I know we also need to probably end this conversation. Let's do this. And certainly Judge Esther and I, there's only two of us. So if we two members are there, and then with you, that's not, that will not be three COAF members having a meeting, but we can perhaps do a telephone conference or something and try to flesh out.
May I make a suggestion?
Yes, please.
So as I mentioned earlier, one of the recommendations from the Justice Gap study was to have this Justice Gap Fund working group to look at the possible, funded internships in legal aid. So I think that discussion and this discussion are related, and so I feel like that maybe we should not be having these discussions separately, but together. And as I mentioned, the plan for 2020 was to, have this Justice Gap Fund working group work on the issue. But because of the pandemic, because of a lot of other factors in our office, we had to hit pause on that. So my suggestion is that, maybe Duan and I can look at getting that work started, and then integrating this conversation and these issues into that.
Okay, and
I mean, that's just a suggestion. If you all think, that a separate group is necessary, then, it is fine to have a working group that crosses sub-entities. And obviously we can figure out how to do that.
All right, no, okay, I'm sorry. And I didn't mean separate group. I just want to get some group going. So then we don't need to run. All right, was that Judge Esther?
Yes, Judge Brenda, I know when we had our phone call with Bonafide last time, we discussed checking in with one another every few months on an informal basis. So maybe that could be the start of the discussion, so we can continue to have discussions between yourself, me, and Bonafide. And maybe in the meantime, staff, we could also talk to staff and develop a work group at a later time. So maybe we can start with our core group of 3. As just to make sure that this doesn't fall out of in sync with our plan, and then maybe we'll follow up with staff in a few months or so to see if we can get this formal work group put together.
Okay, all right, and we'll get your vice chair.
Yeah, I actually was
Ryan in. Yeah, because my pumpkin turns. My coach turns into a pumpkin at the end of September, so I will be off. I will be off COAF at the end of September. But yes, that's fine. In the meantime, we can certainly do that.
Yeah, and given the subject matter that we're looking at, one of our former commission members is coming back because of the financial issues that we're kind of traversing.
Okay.
And he is he's in the financial world. He owns a bank in Southern California. So in this conversation that we're talking about how to manage, and maybe with Jose, manage having these conversations with banks, he would be an ideal person and as also a commission member, to come in and be a part of that maybe core conversation. But we'll talk about it offline. I've already taken so much of your time. I was only granted 30 minutes, and that too already was a gift, and I've now taken on 45 minutes. But definitely this is, I can see that this is going to be a great relationship, and really thank you guys for being open to this conversation and having me be with you.
Well, thank you so very much for wanting to do it and for raising the prospect of us jointly working together. This is really, really good.
The pleasure is
okay.
Thank you,
All right.
guys.
Well, thank you all very, very much. And we will be further in touch. That we don't need any action on that. It was a discussion, so we're not taking any action right now on it. Okay. Well, thank you all.
See you all.
Thanks now. Take care. Bye-bye. Thanks, Dawn. Let's see. We went out of order on the agenda in terms of getting because Bonafide needed to get on and get off. So we still have some other items on the discussion and agenda. We still have to do the update on the first annual diversity report cards. But why don't we go ahead and take our lunch break at this time? And we have about 45 minutes scheduled for it.
Do we still want to take 45 minutes or do you want to shorten it? Up to you.
30 minutes.
Okay.
That would bring us back at about 1:15 though, which would be about when we had planned to go. Why don't we go until 1:15? That's a little bit less than 30 minutes. Does anybody else need longer? Judge Esther? All right. Okay. Why don't we return at 1:15, 1:17?
Okay. Thank you.
All right. Thanks.
Weird.
Okay. So it's 1:17. We'll get going again. We'll go back up to agenda item 6A. The review of the COAF work plan that was approved in May of this year. Elizabeth, anything that we...
Yeah. So Judge Brenda, there was a request at our last COAF meeting that the work plan always be included with the agenda so that everyone could keep track. So
okay.
It's attached for reference.
Okay, all right. So that is there simply for your reference to know what initiatives that we have that we're working on, but there's really nothing to do in terms of review. We seem to be on track with everything. We have a few deadlines this year, but they're going to be met. Let's go to the update on the first annual diversity report card and also the update on diversity summit planning. And Elizabeth, I think you are going to do that along with Christine Holmes and Lisa Chavez and Lisette Garcia. So why don't you all go ahead and take it.
Okay, great. So I'm just going to give a quick update on the Diversity Summit planning, and then we will do a quick walkthrough of what we're planning for our presentation for the Diversity Summit focused on the private sector, kind of giving you a preview. Then we'll have an opportunity to get your reaction and some feedback on the presentation, as well as feedback on the diversity report card itself. I hope everybody has had a chance to take a look at it. And then last, we wanted to give you a preview of what we're going to be looking forward to in terms of our 2021 attorney census. So in terms of the diversity summits, as I mentioned a little bit earlier, we will have sector-specific summits this year. And we are planning our first one for September 11th, and that will be with the private sector. So all COAF members, as well as the incoming members, should have received the invitation for that. It is an invitation-only event, so if you want others to be invited, please let me know and we can get those invitations out. We're also going to have the nonprofit sector summit in December, and we are working with the Legal Aid Association of California to plan that, and I will be reaching out to working group members as we move forward with that. In terms of the private sector summit, our agenda, typically we would have these summits in person, and it would be, a day-long event where we could really get, talk with one another, network with one another, and come up with some next steps and other initiatives. But because, we are living in the times that we are, this will be all of our events will be on Zoom, and, taking into account Zoom fatigue and just the dynamics of having, video conferencing, the summits are going to be drastically shorter. We're planning about 2.5 hours of content for the private sector summit. And what we're planning to do is you'll see just a brief preview of the presentation of the report card, as well as we will have a panel discussion. And really the panel discussion is to help us highlight kind of some reactions to the recommendations and calls to action in the report card, as well as have the opportunity to start a discussion on, what best practices and other initiatives that are happening, in the law firms and in corporations. I want to thank the working group for both the diversity report card. So that's Ryan and Sal, and then the working group for the private sector summit, Judge Brenda, Connie, and Sal for your input. And also want to give a special shout out to Heather, who helped us secure one of our panelists for the summit, Ellen Braverman from Disney. He, along with Hyland Chen, who's one of our Board of Trustees liaisons, but also the managing partner at Munger, Tolles & Olson, as well as Terrence Evans from Duane Morris, will be on our panel. Heather has graciously also agreed to moderate our panel. So with that, I will turn it over to Christine, who will walk us through the presentation preview for the summit.
Great, thanks, Elizabeth. Can everyone hear me okay? Great. So before I start, just to note what Elizabeth mentioned, because we're previewing the presentation for the summit, I will mention a panel presentation that's happening later in breakout sessions that's obviously not happening today. So I just didn't want anyone to get confused when that comes up for the slide. Sorry, there we go. All right. So with the Board of Trustees' intentional decision to focus on diversity and inclusion in the legal profession, the State Bar, with feedback from COAF and other key stakeholders, developed the attorney census to have a baseline for the California legal profession. The census collects key demographic metrics like race, ethnicity, gender, sexual orientation, disability status, and veteran status, as well as questions related to career satisfaction. The first annual diversity report card includes data from the 2019 attorney census for more than 90,000 active attorneys. For a while now, everyone had a sense that the attorney population doesn't reflect the diversity of California, and now we have the data to support this assumption. The hope with the report card is that we will be able to measure the success of the interventions and initiatives to support diverse attorneys in entering and advancing in the profession. The report card also has calls to action to encourage and inspire employers to prioritize diversity, equity, and inclusion, and to improve outcomes. We also encourage attorneys to continue, or in some cases start, these important conversations. So as you know, there's a lot of data in the report card, and I'm only going to go over very briefly some of the data and charts from the card to orient us for our panel discussion and small breakout sessions later in the summit. Keep jumping. The first couple of charts in the report card illustrate the difference between the attorney population and the California population age 18 and older. They highlight where we fall short of having a legal profession that reflects California's diversity. The chart on the left clearly shows that white attorneys account for nearly 70% of California's attorney population, even though people of color account for 60% of the state's population. The chart on the top shows that while women make up 50% of the California's population, they only make up 42% of the attorney population. We see that there is less of a difference between the attorneys and California population for LGBTQIA+, and we will discuss this data point in more detail at the end of the presentation. And the chart at the bottom shows the vast difference between the percent of attorneys and California populations who identify as having a disability. While none of this is particularly new or surprising to most of us, it gives us a frame of reference for how much work needs to be done and a baseline to measure how quickly we are moving the needle. The first couple of charts in the report card, two of which are on the slide here, reflect the change in diversity over time. The newest cohorts in the profession are more diverse than those who have been in the profession for decades. But as the chart on the right shows, the rate of change has varied by racial and ethnic group. The appendix of the report card contains supplemental data tables for people to view, detailing race and ethnicity data by gender for all the analysis of people of color. The report card looks at 4 employment sectors: law firms, in-house counsel, government, and nonprofit. But we also group law firms and in-house counsel together as the private sector. As this chart shows, the majority of attorneys work in the private sector, and more than 1 in 3 work in law firms of 2 or more attorneys. The data for this sector shows that men are more likely than women to work in this sector. And although the majority of attorneys work in this sector, both white and people of color, white, Asian, Middle Eastern, North African, and attorneys categorized as other are more likely than Black, African American, and Hispanic Latino attorneys. Both LGBTQIA+ and attorneys with a disability are less likely to work in this sector. So moving the needle toward a more diverse and inclusive private sector will have a transformative impact on the profession, especially in leadership and workplace satisfaction. Later in the summit, we will hear from law firm and in-house leaders who will speak about their organization's diversity and inclusion goals and how they develop their programs and what they have found to be best practices. As noted earlier, while new cohorts are more diverse, leadership positions across the profession have remained predominantly white and male. The composition of law firms is most, as shown in the chart, is most similar to the statewide attorney population, which is 2/3 white and dominated by men. As you can see, women and people of color are underrepresented among law firm partners and in-house counsel executives. As noted in the report, a diverse organizational leadership structure demonstrates an entity's values to its workforce, clients, stakeholders, and community. Attorney leaders mentor, advise, and provide access to information and opportunity. When leaders are diverse and demonstrate a commitment to inclusion and diversity, They can drive a workplace culture that supports the recruitment, retention, and advancement of a diverse workforce. And that leads us to how satisfied attorneys are with their workplace. We compared workplace satisfaction by the 4 sectors I mentioned earlier. In the attorney census, attorneys were asked to rate their level of satisfaction with 18 workplace factors, according to a scale of satisfied, neutral, or dissatisfied. The charts in the report are based on composites calculated by taking the average percent satisfied for the 6 factors listed under each of the 3 workplace experience domains in this chart: individual, career, and workplace issues, collective workplace issues, and work-life balance. As you can see, the most prominent distinction in this chart is that attorneys employed by law firms are more satisfied with individual, career, and workplace issues than corporate counsel and attorneys in government and nonprofit sectors. And I want to also note at this point that the 2020 attorney census career satisfaction questions were revised and include questions related to rank and compensation. The data analysis is not yet complete, but we plan to present some of these findings at the Diversity Summit. So I only went through a fraction of the data in the report card, and as noted at the beginning, most of the data doesn't show anything most people weren't already aware of. So what do we do now? This leads us to creating a call to action. Like the data highlighted in the report card, our call to action focuses on opportunities in the areas of workplace leadership and satisfaction. Through a combination of statements and questions, we engage both employers and attorneys on issues that have the potential to impact the recruitment, retention, and advancement of a diverse workplace. The call to action in the report card is by no means an exhaustive list of actions, but as with the data, it provides a baseline that we hope to build on. The leaders of our panel will discuss the actions from the calls to action, as well as other actions they may have taken to help them create a more diverse, equitable, and inclusive workplace. We will also ask participants to break out into small groups after the panel presentation to discuss the call to action, what they have used, what they plan to use, and to share successful actions they have taken that are not on this list. Are there any questions?
Okay, if there aren't questions, it would be great if we could get some feedback about either the presentation, other data points you think would be important to share out during the summit, or about the diversity report card in general. We're particularly interested in hearing more from you if you've been able to utilize the report card, share it with your colleagues, what parts you think were particularly useful or not so useful, and actually, even how we visualize the data. I know some of you had been involved in some earlier conversations where we were hoping to have a little bit more be able to have the data on the website and have it be more interactive for folks, which is something we will be working on, and I think Lisa will talk a little bit about that momentarily. So any comments or feedback from anybody?
Yes, I have some feedback. So I shared the diversity report card with the decision makers at my law firm. It's a pretty large firm, 8 offices throughout the state, and the executive board raised a discussion about increasing diversity and inclusion at my firm, but they had deeper questions, and what ended up happening was one of the board members came to me and asked me if I had any additional input, and with that I was able to relate information that we gathered from Dr. Reeves and her best practices and her suggestions about increasing diversity and inclusion. And if there was a way we could kind of incorporate information in the next diversity report card about best practices and how to actually structure D&I so that there's a lasting impact, from the experts, that would be great.
Thanks, Ryan. So we did work with Dr. Reeves on the calls to action. She provided a lot of input on that. So hopefully you could see some of that, but that's a good point that you raised.
Yes, I certainly noticed that. What they were actually figuring out is like really digging into a little bit of the minutia of how to actually and practically approach these things from an administrative level. And those are the questions that are kind of unanswered that decision makers kind of need to understand and figure out so that they can actually apply it in their organizations.
Christine, Donna Shealy here. I am hoping that the data on women, both white women and women of color, does not get lost in this report, because on that one slide where you showed the groups in a firm versus partners, those were the two groups that really decreased from attorney to partnership. The men of color were pretty close. And of course, white men were overrepresented. So the overrepresentation of white men seems to have come at the cost of opportunities for both women of color and white women. And I really hope that that doesn't get lost in this.
Yes, thank you, Donna. And it is, I did only briefly go over that, but that is a point that is mentioned throughout the report, that very thing, that it is at the cost, particularly to women of color who are less represented in leadership positions.
Go ahead. Sorry.
Me? Should I go ahead?
So yeah, we have
Okay.
Pat, Sarah, and Michael who have comments.
You know, when I'm looking at this, and I like all the data, and I like the way it's laid out, but you know, I really like the way you have it laid out on the slides, because it's more compressed. And if there's some way when you do the final printing of the report, so the charts and the graphs and so forth aren't so spread out, and it makes it seem more like a full report instead of like a report card kind of thing. So that if you could do both versions, I think it's easier to do that if you can kind of put the explanation with the data that you have laid out on the slides, like 2 pages on one slide. I don't know if that's possible to do that with the notations you have, but when I hear report card, I kind of thinking that it should be a report card and be a little more compressed and easier to use in terms of flipping through, especially as a summary. If it's possible at this point in this stage, when we're talking about diversity and inclusion, we should be talking about diversity, equity, and inclusion. You know, diversity is the variation in the numbers of the various demographic constituent groups. Inclusion is how valued they are and how supported they are within the organization. But the equity has to do with the fair and impartial distribution of resources and support. And when you look at the call to action, I was looking at the language under some of these, and they do incorporate the concepts of equity, but the way people are looking at this area now, it's basically diversity, equity, and inclusion. And I think that's important because some of the feedback that you have here in terms of satisfaction has to do with the equity aspect as well as other aspects.
Thanks, Pat. Just want to clarify. So the report card, the link that was in the agenda, so that's what's we've published. So we're not.
Oh, it's already published? Oh, sorry.
So we're not going to be able to make the changes that you suggest. But in the future, I think the report card will have a totally different presentation. It's because we want to be able to have it be a little more interactive and useful for particular law firms or organizations
that
might be looking at the data.
I was just going to say that it might be interesting to compare some of the data from the California diversity report to national data, as you know, there's a zillion different surveys with demographic data on lawyers. Nationally, it's probably NALP. NALP does, national breakdowns. They do an annual report, and then they do it by various geographic areas like San Francisco or LA. So it might be interesting to compare California to the national. And then I was also wondering, within the California diversity report, have you looked at, like the Bay Area versus LA or San Diego? Has there been any sort of geographical breakdown there? Because that could also be sort of interesting.
Lisa, I don't think we've looked at the data that way.
Hi everyone. I'm Lisa Chavez. I'm the director of Araya. We have not looked at any regional analyses, but I know that's something that we're interested in.
Hi, this is Pat. I would support that, because when you take statewide data, it doesn't reflect the various counties within the state. And when you look at LA, for instance, the demographics, the actual demographics compared to the attorney demographics are different. There's obviously a higher rate of Latino, Hispanic attorneys in LA as opposed to throughout the state. So when you want to do a true analysis of the diversity of the profession compared to the population, it's more accurate to do it by county.
Michael?
Thank you. So I want to thank Elizabeth and especially Lisa, because they've both been fielding a lot of emails from me in my capacity with SAC Legal, the LGBT Bar Association, and working with other LGBT bar associations across the state when it comes to this survey. So thank you both, because you've been really, really helpful. I know that there's a lot of data out there, and a lot of people just want to get into the data. And one of the things that I mentioned in the emails is, I think, to the extent that the data can become publicly available so that other organizations can do their own deep dives, or firms can do their own deep dives into the data, that would be particularly helpful. I want to echo to what Donna said about intersectional identities, especially I think probably for law firms, it's a key point to see how women of color, LGBTQ women of color are represented in a lot of these boxes at a lot of these levels. I also wonder whether, and I don't think that this is in the report card that was released, whether there's a breakdown of the demographics based on years of experience, because obviously the pipeline is going to change for partner track or people who are going to go in-house or things like that based on years of experience. I think that could reveal some patterns that could be, could make us hopeful, or could be a little bit more concerned.
Okay, is there anyone else? Thank you, Michael. Is there anyone else who has any thoughts or comments? Elizabeth, any other hands raised?
I don't see any other hands raised.
Okay, all right. Anything additional from you, Elizabeth, on this topic?
We did want to, if Christine, if you could advance the slide, we did want to preview the 2021 census.
Okay.
Okay. Hi everyone, I'm Lisa Chavez and I'm the director of Araya. I'm here with Lisette Garcia to talk to you about the analysis we're conducting right now on the 2020 attorney census, as well as changes we're making for the 2021 census, which will be available for attorneys to fill out when the new fee period opens in December. So with regards to analyses of the 2020 attorney census, we are currently in the process of analyzing that data. We're also planning to release the data online in dashboard format. So rather than getting a PDF traditional report, instead the analysis will be available online in dashboard format that will allow users to interact with the data and conduct analyses beyond those that we say already create canned reports for. So that's one goal for this year. And another goal is, our goal for our 2020 results. But looking forward to the 2021 attorney census. So far, we're going to keep the attorney census mostly the same. We just have some minor tweaks to make with regards to language, things we realize, little misspellings, adding maybe a few more options where, like, there's examples where they had someone had the option of checking like an other. There should be an option to like fill in what that other meant, things like that. But the one big change we're pursuing is we need to make an adjustment to the gender identity question. We received really good feedback that the gender identity question as currently constructed really doesn't allow us to fully capture transgender attorneys, that allows them in addition to express their gender identity. And so we've been working with Mike. We're going to start working with Michael Rhodes and other stakeholders. Hi, Michael. I know I owe you an email, but thank you for your emails. You've given us a lot to think about, and that's just a huge priority. So we're going to be working with Michael and other stakeholders on revising that gender identity question so that accurately, like I said, captures the number of transgender attorneys in the state, as well as lets them express their gender identity, which are two different things. So, but the way the question is right now, it's like all in the same question. So we're going to try to figure out if we have to break them apart or something. So that's what we're really committed to, and that's what we're working on moving forward. And sorry, and one last change we're going to make is that right now the label for to identify non-heterosexual attorneys is LGBTQIA+, and the truth is that the T the T, I believe, usually stands for transgender. The thing is that particular variable in our research, we don't include transgender attorneys in that group. They're counted up in the gender analysis. And so again, this is something I'll talk with Michael about and other stakeholders, if it makes sense to either change that label or just use it, but explain it. Explain what it means and who we're capturing and who we're not with that label. Okay, so I'm available for any questions you may have about our plans.
Oh, I have a question. Are you going to add a non-binary category as well?
I believe I have one.
Because just for data purposes, NALP just adopted a non-binary category this year for all of its, demographic charts that go to law firms all over the country. So I think that is something that's important that should be considered.
Actually, let me share my screen and we'll look at our current question together. Okay? Can you give me sharing rights? Okay, I have it ready to go. Okay, almost there. Okay, so here, this is what it currently looks like. And see, so are you suggesting like non-binary, say like have its like own box?
Yeah, I don't know.
I don't also like the way that question is particularly worded. Okay. in a gender identification. If the question is looking for gender identification, then
and then it says, what is your gender?
Right. It says what is your gender? I mean, it's also difficult to reword that, because if you want to use the term cisgender, most people won't know what it is anyway. Which is a separate issue. But normally when this question is asked, it's asked in a different way than the way we're asking it here. So if we really want to get an accurate sense of, if we're really trying to count people the way they identify, I think we need to work on that question a little bit.
Absolutely. Okay, so this is a huge priority for us and something we'll be working on intensely pretty much over the next month, the next 4 to 6 weeks, because we need to load it into the system so that it's all ready to go when attorneys, when the fee cycle opens up.
We have a comment or a question from Heather and then from Michael.
That was my question, is was it going to go out with the fee payment? Are we aligned?
Yeah.
Okay.
So the way we administer the attorney census is that so right now it's still available online. If an attorneys can log into my State Bar profile, and if they wanted to update the answers, if they wanted to fill it out, period, because again, this is an optional survey. So if they wanted to fill it out at all, or they wanted to make any changes, they can go into my State Bar profile and then they can make changes. And what we do is our plan is to take down the survey November 1. And then at that point, our IT folks make the changes that are needed. And then it'll be online when the fee period cycle opens in early December.
But when you pay your fees, will you get a notice that you should, we're encouraging people to complete the census? I recall last year, a lot of people I talked to weren't aware that the census was available, hadn't seen anything about it. So somewhere in the flow, people weren't being notified.
Right. No, the way it should work is that when the fee period opens and an attorney logs in, they're made aware of it. That's the first thing, that's the first screen they see. And they're made aware of it, and they're encouraged to fill it out, but they also have the option of skipping through it. We were aware last year that there were some bugs in that program, whereas some people logged in and they didn't see that. So then they went ahead and filled out their fees, and we did some outreach to people. We saw, hey, you didn't fill out the survey, please fill it out. But yeah, this is always a work in progress, building a survey of this magnitude within my State Bar profile. We've explored other options. So for example, using something like Qualtrics and emailing attorneys saying, please fill out the survey. We've gone back and forth, countless discussions. And I think for this year, we've just landed on keeping it within my State Bar profile, because we know that attorneys will log in to pay their fees. And that's where it's the best place to encourage them. It's very easy for something to get lost in an email.
Agree that that's the best place. Can you share with us the copy that attorneys see to encourage them to participate in the survey?
You mean the email? I mean the text?
Yeah, the text that's around it.
I don't, let me see if I have it. I don't think let me see if it's here.
I kind of recall, maybe Judge Kristen, did you participate in helping us look at this last year?
I did, Elizabeth, thank you for remembering.
Yeah.
and apparently, according to Heather, I didn't do a very good job.
No.
I know, I'm teasing you, Heather. So we did rework the language a little bit. I mean, it's tough because this is the amount of text we have right here to get people to fill out the census, and it's maybe we need to do a better job of messaging it. Maybe we need to message it in a different way, but this is really a small amount of text that we have. We changed it up a little bit last year, but not significantly. And I don't think Donna Hershkowitz is on the call anymore because she and I worked on it together. If we didn't make a lot of changes, the thing, it's getting it out to everyone. And because it's not mandatory, it makes it harder to message.
Right. Well, and that being said, I have to say, there were, over 90,000 responses, which is a very good response rate. Even though I'm not a statistician, I think Lisa can speak better to that. I feel like we did pretty well.
Okay.
That sounds great. And I think the text is exactly what I was looking for. I was just, again, I know several people that I went back and said, did you fill it out? And they were like, where was it? I didn't see it. So one thing to take into consideration from an IT standpoint, and it may not be in time for 2021, but in the future, instead of having it be in that top bar above where you put in your bar number. Perhaps it can be a pop-up that you have to X out of. I work in the tech space. So, and so I know when we want people to see really important messages, that additional affirmative step that, you know, might catch their attention a little bit more. Cause I think the text is exactly what we want to say, but because you can just go right there to put your bar number in, you may not even focus on that.
That's a great idea.
Thank you.
Michael, do you have a comment?
Yeah, I know I've talked a lot about LGBTQ data that y'all have collected and have gone through. I had a question actually about how we define people of color in the survey. I actually had a coworker that raised this issue with me. She's multiracial, and she asked whether this, for the State Bar survey and the report card, whether do we have a separate question that says, do you identify as a person of color, or is it just anybody who's non-white that identifies as a person of color? I think that she, as a multiracial person, had a unique...
It's anyone who identifies as non-white.
I don't know. I'm not a person of color. I am not a specialist in this field, so I don't know whether there's a best practice of including that question, and maybe that the question of do you identify as a person of color should be included going forward.
Mm-hmm.
So in other words, Lisa, you're saying that this doesn't track, for example, the EEOC definitions of multiracial.
The way we
the EEOC says, do you identify as a member of 2 or more races, but not Latinx? It's very, I don't know why it's that way, but.
And the way we identify multiracial people is if they selected more than one of these categories right here.
Okay.
Right. I think also it's different in the census, and I think what you're talking about, Sarah, is that they ask people to identify as Hispanic, yes or no. And then everyone is out, and then the next question is, what is your race? And then there's no category for Hispanic there, because the idea is that Hispanics can be of any race.
Oh.
Yeah.
This is Brenda. We had a comment from Genevieve Jones-Wright. Genevieve, you want to go ahead and ask your question? Are you there, Genevieve?
Can you hear me?
Yes, now.
Okay. So I'm just wondering if we can maybe ask if persons are even comfortable with giving an answer about gender identification, or, you know, along that line. I know that normally there is an option for prefer not to say, but I think maybe if we make the questions a little more expansive, that would be a better way of getting the answers and a better picture in a more compassionate way. So first ask if people are comfortable with that, but then instead of saying gender identification, what is your gender, perhaps asking something along the lines of, do you consider yourself to be, and then give those same options, except I would think maybe having transgender be a different question, because obviously you can be a trans male or a trans female, and if they're comfortable enough with saying they identify as a male and then that they also identify as trans, then we get more of the information, whereas it looks like it's sort of kind of just all lumped in and we're still not getting the broader picture. So that's just some of the thoughts that I'm having in a way that we can possibly change the questions to be a little bit better.
So just so I understand you, are you the part where you said, are you comfortable discussing or reporting? Do you think you're suggesting it should be an option here, like would rather not say as a last category? But I understand the idea of like having transgender as a separate category. I think that's definitely something we're considering. So this way it's like, do you identify as transgender, however it should be, yes or no, would rather not say, and then what is your gender identity, how do you, et cetera. here, and then transgender would not be here. But are you suggesting, I'm trying to understand where you're asking us to consider putting, would you rather not say, are you comfortable talking or just reporting?
I would say right before this question, identification, it can be the preceding question, because some people, whether they're even cisgender, may not want to identify in any way for whatever reason. And so then also just having that data to go back to and saying that some folks did not participate in this portion of the survey.
Yeah, I think we're capturing that because all these questions can be skipped. Like, see at the bottom, we have that skip option, and we do have a decent percent that don't answer this, but you know which the question where most people opt out of? It's the sexual orientation question. Like, people choose the skip button. We don't have to worry about people not using the skip button. Go ahead, Michael.
I appreciate that suggestion, Genevieve, because I know that this is can be a particularly sensitive topic for some people. I get really frustrated personally when I see that, you know, a third of respondents decline to state sexual orientation data, because it just makes it harder to capture some of the potential biases, potential difficulties. But at the same time, I'd rather people have the option to skip, you know, one question than stopping the survey because they don't want to answer it. So I appreciate the skip button, even though I'm a little, I prefer everybody just answer everything, but.
I guess what I was saying was that just an option would just be prefer not to answer, which I guess the skip button essentially is, but it's acknowledging that some people don't even want to pin themselves into a box, even though they may have a certain sexual orientation or identify as a certain gender, but just recognizing that they don't want to put themselves in a box. So, but you're right, there is a skip button, but.
So maybe like so for each of these, a category would rather not say. For each of these, like would rather not report. Just the way it's like they're letting us, it's like a vehicle for people to let us know. Because right now we're just interpreting if they skip, that they're just skipping because they don't want that. But it sounds like you're saying it would be really, if people had that option, we'd really be learning how many people are opting out, and then perhaps what can we do about it?
Yes, because sometimes you can skip something with the intention of going back, because something like your race and ethnicity, you may think, well, what is here is not what I identify as, or, you know, what do I want to identify as? So you go to another question and you skip and you intend to go back, but you don't. So that's going to be an assumption about why you didn't complete that question. Whereas if someone actually says, I prefer not to state how I identify, or whatever the case may be, then you know for certain.
Right. I see what you're saying. Well, thank you for that.
Judge Yu has a comment. Judge Yu?
Oh, thank you. I just have, in filling these things out, sometimes I see people just say decline to state instead of I would rather not say, because it's just shorter and very clear that they're not skipping it to come back.
Decline to state. Okay, perfect. Well, we will explore all the different permutations.
Are there any other comments or questions? I don't see any. Oh, Michael?
I'm sorry. One other brief question, which was, are government attorneys going to be, I have a vested interest in this because I'm a government attorney. Are they going to be involved in the nonprofit diversity summit?
Oh, that's a really good question, Michael. So we had actually planned to have a separate government sector summit. That's a mouthful. And because of the pandemic, we actually were going to start having summits in May, but have had to push things. So the government sector summit will likely be like the early part of 2021. And obviously we're going to tag you to, you know, be on the working group to help plan that. So stay tuned.
I'm the host. So anyway, I just wanted, for closing, I just want to say, again, my office led the research and writing on this project in a partnership with Access and Inclusion, and I just want to thank everyone who gave feedback on it. We appreciate your support. This project was like a heavy lift, a few years in the making, and we're all really pleased with how it came out. But seeing that big report, it just confirmed to all of us that this needs to go online. This is very old school to have like a 40-page PDF. No one reads those things anymore. And if the goal is for people to see it and absorb it and like do something with it, we know. Message is clear. This information has to go online, and the truth is, the best part is that it's data that lends itself to going online. So if you flip through the entire report and you look at all the appendix tables, like everything's just changing by like sector and by like demographic analysis. That's it. Like those are the main kind of cuts of the data, and that really lends itself well to putting this online in dashboard format, so then users can see it in different ways. So really excited about that.
Thank you,
Very
Lisa.
good.
Also, I really want to give Lisa and her team a really big shout out, because this was a huge, huge lift, and our office asked them all the time, all the questions, and they were super accommodating and explaining everything to us. Carolina Almirante, who COAF has met often in these meetings, she actually, we got her to come over to our shop. So we thank Lisa for that as well.
That's great. That is good. Well, thank you, Elizabeth, and everyone else on that one. We really appreciate it. So let us move on to the next agenda item, which is, we're going to go back to the consent agenda. We skipped that one. And that consent agenda is to approve the minutes, the summary of the May 29 meeting. That was attached to your agenda. Has everyone had an opportunity to take a look at it who needs to? And I will entertain a motion to approve that
And I have
summary.
this is Esther.
All right, is there a second? I'm sorry, who seconded it?
Ryan Harrison.
Okay. All right, it's been moved and seconded that the summary be approved. All in favor?
I'm sorry, Judge Brenda, we have to do a roll
Oh,
call.
I'm sorry. I keep forgetting that. You would think that by now I would know you have to do a roll call vote, and then you make a big note for me to have you take a roll call vote. Elizabeth, please take a roll call vote.
Judge Brenda.
Aye.
Judge Esther.
Aye.
Heather.
Aye.
Connie. Ryan.
Aye.
Genevieve.
Aye.
Emily. Kristen.
Aye.
Donna.
Aye.
Val. Okay, so the motion carries.
All right, thank you. We'll move on to the next agenda item, which is an update on the plan to address the law school retention. And Crystal is going to take the lead on that one. So we have Crystal on, Elizabeth? Crystal Van Dam?
I think she's unmuting herself.
Oh, okay.
Hi, can everyone hear me okay?
Yes.
Yes.
Okay, perfect. All right, happy to get started. Good afternoon, everyone. My name is Crystal Bending. I'm a senior program analyst with the Office of Access and Inclusion. I will be providing a couple of updates for the working group regarding law school retention. Members of the working group are Sal and Donna. Briefly, just wanted to remind COAF about the strategic plan as well as the related work plan activity regarding this working group. So that's goal 4, objective H, which is to identify means of supporting law school programs to improve retention by December 31st. And then the related work plan activity of this working group is to develop a Best practices guide. I lost visibility to the screen. I was wondering, did everyone else lose visibility as well to the PowerPoint?
Sorry, I'm having a hard time getting the full screen slideshow to work. Sorry, Crystal, I don't know if you want to.
Can share my screen.
It's just not entering a full screen.
Let's see. There's not that. Okay, let me try sharing my screen. I have it.
Erica, you might have to stop sharing yours so that Crystal can share hers. Thanks.
Sorry, I don't see it on my. So Elizabeth, I can't find it on. Oh, perfect. Okay, great. Again, just a reminder, as well as the work plan activity, which is to develop a best practices guide or resource to distribute and promote the guide to guide or resource to the public. So with that, I'll go ahead and provide some working group updates. Sorry, prior slides, thank you. So after our May meeting with COAF, the working group met in June to brainstorm some potential topics for a second round of a law school retention survey. As some of you may recall, we did do an initial survey last year. We got a lot of information from the law schools and, kind of create our baseline. And we also looked, the working group also looked at additional literature. So we figured in order to best meet the work plan activity, we were going, they wanted to establish a second round of a law school retention survey, this time looking to get more specific information, kind of to help structure whatever that resource or the best practices guide would be. So Sal and Donna gave some really great ideas as a starting point for topics and areas that we could ask the law schools about. So at this point, we're currently working with Araya. Thank you, Lizette and Lisa, very familiar names at this point, to kind of finesse those survey questions. As the initial point, and we also, for this survey, we're going to be incorporating law school feedback before we finalize and administer it. So we've been reaching out to the law schools. I believe we have about 5 schools, both from ABA, Cal accredited, and hopefully the registered law schools as well, to get their input to just make sure that we're using the right language, capturing all the information that we may not know because we're not, in the law school environment. So as for next steps, go ahead and advance the slide, Erica. So as for next steps, we're just we're going to be in the process of gathering preliminary survey feedback. Those law school contacts have also graciously volunteered to beta test the survey. I think we're discussing with Araya on how to move that survey onto Qualtrics, which is the survey platform, and finalize and administer the survey in the fall. We're hoping and pretty optimistic about the type of feedback we'll get back, and hopefully just more information that we can synthesize into a best resource guide, pull some highlights of successful programs in other schools, and just kind of recommendations for all the California law schools to use in the future. I'm happy to entertain any questions at this point. It's a very brief update, but we've been busy and in contact with the schools who seem to be excited about the second round of survey.
I don't see any hands raised or any comments.
All right. So then, then thank you. We'll move on to the next. All right. Thank you, Crystal. We'll move on to the next agenda item.
And real quick, thank you, Crystal, for presenting that report of our committee's work. I appreciate it.
Yes. And I thank the members of the committee as well. Thank you. The update on next agenda item is the update on efforts to institutionalize diversity and inclusion goals. And Heather is going to give us that update.
Hi, everyone. I think Dawn is going to be my driver on the deck, right?
Elizabeth is actually pulling it up, right, Elizabeth? If not,
Okay.
Yeah, I'm pulling it up. Sorry, I just, for some reason, am not able to.
Oh.
Sorry for the technical difficulties.
Want me to, Elizabeth?
Yeah, I apologize.
Sorry, give me a second, Heather.
Oh, no, I'm sorry, I got it. Here.
You got it, okay.
Okay, thank you. So just a reminder that our working group is comprised of Elizabeth and Dawn, as well as Genevieve and Sal and myself. And if we advance to the next screen. So this is also goal 4, objective I, that no later than March 31st, we would identify ways that diversity and inclusion principles can be institutionalized in the bar exam development and grading analysis, and implement these practices no later than December 31st, 2020. We think we're going to need to ask the board for an extension until next year to complete the work plan goals, in part because of disruption around COVID and the quarantine. The 2020 work plan was to recommend and develop state bar rule to codify diversity and inclusion principles in the bar exam development, work with the Office of Admissions to broaden education of and outreach to the legal community, including affinity bar associations to widen recruitment of graders and pre-testers, and examine previous bar exam questions analysis that had identified differences in performance and develop relevant procedures for exam development. So prior to the quarantine, like a couple of weeks right before, we had a meeting with the bar, and it was really productive, I think. And as part of that, we were able to get some changes made. So from co-op suggestions, they implemented demographic questions that have now been added to the grader application as of July 2019, so that we can get some better understanding. Shouldn't that be 2020 now that I'm thinking about that? Wasn't it July? I was like, wait, we had the conversation in March. But so that we can get a better understanding of who is applying and what the diversity of the applicant pool. Secondly, a hiring matrix has been created to mitigate bias in the hiring of graders. We wanted some idea of how things were being weighted with respect to what was analyzed for selecting graders. All graders must participate in implicit bias training, and we pushed all of us on this council pushed to have that in place before the February bar, and they made that happen. We're very happy about that and the continuation of that occurring. Calibration sessions conducted via Zoom. I'm personally very proud of this because in that conversation, we had a long discussion about being able to conduct the calibration sessions via video. And the reason for that was really to address the issue of where we pull the grader pool from. Right now, currently the requirement is that you live within, I think, 20 miles of San Francisco. And in our previous meeting, we had all discussed how that might create some systemic issues because it's very expensive to live in San Francisco or within 20 miles of it, and that might be impacting the diversity of the grader pool in and of itself, and encouraging that perhaps we could extend into Southern California to help increase diversity. And the response that we received was that the problem with that was that they needed to have these calibration sessions and they needed to conduct those in person. And in order to, and those occur in the San Francisco office. So trying to determine how they could do that without needing to bring people up from Los Angeles. But then 2 weeks later, we all went into quarantine and suddenly we had to figure out calibration sessions via video. And so sometimes things just kind of work in your favor in a weird way. And they have been able to figure this out. They had a few hiccups at the beginning as they were using Skype, But since they've moved over to Zoom, some of the things they were concerned about with respect to being able to really read the room, they found that they've been able to do so. I think that's a huge win for us, again, to be able to address the bigger concern for the council that we can now have an argument that they should determine whether they can expand the grader pool to other parts of California. And then finally, they provided demographic data for 84 apprentices and graders for the February bar, so that we had better insight into who the graders, who was, who's grading. There were a high number of unreported graders that didn't want to share their demographic information. So we'll work, as part of all this, we're going to work with admissions to develop a more targeted and strategic outreach plan. And we're going to suggest collecting demographic information on graders, on grader applicants, not just the ones that are selected, so that we can start to get, again, an idea of what the application pool looks like. And then if we move to the next slide. So our next steps, a couple of weeks ago or a week ago, we started to deep dive into the actual DIF report. And what we determined was that we need to talk to Ron. So we are scheduling a follow-up call with him to kind of work through and walk through the report in more detail. We just had questions that our working group couldn't answer for each other. So that will be our next step, so that we can begin the examination of the bar exam questions and then update everyone at the December meeting.
And just a quick update. So the working group regarding the DIF report is actually going to be a working group with some members of the Committee of Bar Examiners, CBE. And so it's our understanding that they had their meeting last week and are gathering their volunteers. And so the plan is for the COAF working group and the CBE working group to meet in mid-December with Ron to go over, as an orientation session, to go over the report and the actual questions.
Mid-October, Elizabeth, not mid-December, mid-October.
Oh yeah, I'm sorry, mid-October, yeah.
I have a question. I know that we did get the implicit bias training for the graders. What curriculum was used? How long was the implicit bias training? I mean, did they get an hour, 2 hours, a half day?
I believe it was a few hours, Judge Brenda, but we have a pending question for them because Heather had the same question about the curriculum and who was the presenter. So we can get that information back once we have that information.
Yeah, I would like to know what the agenda and who the presenter was, and also what was the curriculum? What were they taught?
Sure.
And who approved the implicit bias curriculum?
Sure, we will look back with admissions and ask, and perhaps if they have a PowerPoint or something, we can share that out, the materials with everybody on COAF.
Okay, because there's implicit bias training and then there's implicit bias training. And we really would like to know, we want to make sure that the implicit bias training is effective and it's going to reach the issues. There are a number of different providers of implicit bias training, but it would be good to make sure that that we have training that is really going to make a difference and be transformative.
And as you all may recall, we also suggested that the staff for the bar exam also get training. My understanding is, I think as part of their overarching training, they receive some as well. And eventually the proctors as well. So just want to make sure everyone that's a touch point in this process gets that training.
And Dwan, when will we know that? Do we have any information about when everyone else involved in the process will receive implicit bias training?
We don't have, but we can ask admissions. Like Heather was saying, with the staff, it's part of an overall kind of staff implicit bias training that the State Bar is doing. So we're not sure if they have a separate one just for admissions, but we can ask. And I know we had suggested that the proctors receive training. They couldn't make that happen by the February exam, but admissions is a little bit backlogged right now because of everything that's happening. But we will definitely follow up with them.
All right, and we have a schedule or something for any new graders coming on as to how soon after they get selected that they will have the implicit bias training. Do we?
We don't have it scheduled. We've just been told that it was offered, but again, we can ask.
Okay.
And I don't know if you saw, but Elizabeth did send out, because admissions sent to us the application for the next grading pool. So if you're interested, or if you know anybody else that's interested, please let us know and have them submit that. And if you have names, perhaps we can pass them along and highlight that so that admissions is aware that that's coming through as a cooperative mention.
All right, great, thank you. Are there any other questions or comments on this topic? If not, thank you, Heather, on behalf of your team. And thank everyone for that participation, for that report, rather. Let's move to the next agenda item, the update on the request from the Committee on State Bar Accredited and Registered Schools. And Judge Christian, you're taking that one.
I am. Thank you, Judge Brenda. And Donna is also on this group with me and did a lot of the heavy lifting. But I said I would present because she's got a lot of other things going on and teaching school online. So Donna, please jump in if I forget anything. And Elizabeth, are you in charge of this for me?
Erica's going to run it for you. Thank you.
Okay. So for new folks on COAF, welcome. And just a quick sort of background on this. CS Bars asked COAF if we could provide feedback on new diversity, equity, and inclusion language that would be put in the rules for California accredited and registered law schools. Those are the law schools that are not ABA accredited law schools that California still operates and can operate. Donna and I looked at this language when it first initially came out, and we had some questions about the language in there, in that it included language that said anti-discrimination policies that were consistent with the school's mission. One of the issues for Donna and I, as we looked at this, was that there is one registered law school in California that openly and explicitly discriminates against LGBTQ applicants. And we had some questions for the Office of Admission about how that law school, how that discriminatory policy fit in with the State Bar's statement that we would be working on diversity, equity, and inclusion. And so we met again with Natalie Leonard, who I don't think is on this call, but is a brilliant wealth of information from the Office of Admissions. And we discussed that what the State Bar is really looking at for these types of registered and accredited law schools is really whether they're meeting the registration requirements. And the State Bar isn't really, it really isn't about policing how that happens or how the curriculum is conducted. And Natalie went over a little bit of the case law with us and explained that California law seems to permit this type of discrimination if it's a religious organization, and this school is registered, I believe, as a religious nonprofit, and Elizabeth can correct me if I'm wrong. And so what we were left with was that perhaps the best language we could put in there was consistent with California law, but that we had made it clear to at least the Office of Admissions that that as members of COAF, we didn't believe that the State Bar should be in the position of endorsing schools that openly discriminated against LGBTQI plus applicants. The language was, the language went forward, and I guess it went to the Committee of Bar Examiners in the end of August, and they sent it out for study. And if new language comes back, Donna and I will review it, but as of right now, I think it's out for study with the Committee on Bar Examiners. So, did I forget anything? Donna, Elizabeth?
Sounds great. I will be off of COAF at the end of September, whatever that date is, just to let you know.
Yes, and I will miss your contribution and Connie's and Emily's and Genevieve's, as I know.
But I'm happy to, help in any way that you need.
Okay. Well, I may drag you back into this discussion because, as many of you remember, as I said at the end of the last meeting, this is obviously a big issue for me, and it's not one I intended to let go. So.
Thank you.
I'm saying it in a nice way. But.
Very good. Very good.
So
okay.
Yeah.
All right, then. Is that it, Kristen? Is that your presentation?
That is everything I have on this issue.
Okay.
Yes.
All right. Are there any questions or comments from anyone?
Yeah, this is Pat. I probably should have asked this when you were talking about the retention issues, but what is there any way to show the California accredited data by raw data instead of by percentages?
I'm sorry, what data are you talking about, Pat?
The analysis of the California accredited law schools, the statistics, demographics, anytime you're looking at the California accredited, because I mean I understand, and this has always been the understanding that the California accrediteds provide opportunities for attorneys from diverse backgrounds to attend law school. But when you look at the data, their performance, their retention, their bar passage and everything else, and even just the numbers of students attending those schools, and then the numbers of actual diverse students, it's very small, and their performance is really not that good. And the question is, do they provide the kind of education that allows those students to actually pass the bar exam and become attorneys? But the data that we see here, I guess it was in another report where it's comparing the percentage of bar pass and so forth and demographics to the ABA accredited law school, and it's all by percentage. And it's a bar graph, and in some instances the Cal accrediteds seem to have a higher or a comparable percentage of diversity. But the numbers, if you use raw data, it's very it isn't comparable. But I think we need to get an accurate picture of the California accrediteds. And when you're talking now about accreditation standards and so forth, you need to also address not only their diversity standards, but their performance standards, to be sure that they're providing the level of education that the students are paying for, and that they have a higher probability of passing the bar exam.
So Pat, the State Bar has been working on refining the additional questions that the California accredited and registered law schools provide. It's called an annual report that they submit to the State Bar every year. And so ORIA has been working to develop additional questions so that it more closely mirrors what the ABA schools are required to report, so that we can do some analysis comparing them. And so this year, for the first time, they'll be completing that report. And so this law school retention working group will actually be able to take a look at that data when we get that, probably not until early 2021.
But we have some data, don't we, Elizabeth? I mean,
we do, and we've presented that before to COAF. One of the issues is it's not as robust as what the ABA schools report. And so I know there's been questions before of comparing the two. And it would be like comparing apples and oranges, and it wasn't something that we've been comfortable doing. And so over the last probably year and a half, almost 2 years, we've been trying to develop these additional questions for the Cal accredited and registered schools. And so this fall, they'll be completing those new surveys, and we'll have that data to look at next year.
Okay. And with respect to our liaisons, if they want to be on a working group, they can also serve on a working group, correct? Now that we have them, but their expertise is very good. So I just want to throw that out there too, so that that our 3 liaisons can certainly get some information and point people in the right directions as well.
I volunteer to help you on that committee, because I've always been really interested in upgrading the standards for the California accrediteds.
Well, we're not upgrading the standards.
Well, you're not upgrading the standards. What are you doing?
I mean, we're providing input on their accreditation rules, but we don't have the power to upgrade their standards.
I mean, not ABA, California accrediteds. Are we trying to ensure that the California accrediteds are providing the quality education so that?
That is not our charge. Our charge was looking at the accreditation rules to provide feedback with the DEI lens. So, I mean, you know, I can provide some more information to you offline, Pat.
Okay.
Right. But you'll still work on the
I'll help you. I mean,
all right. That's great.
You know what to do.
All right. Excellent. That is great. All right, Kristen, if there's nothing else from anyone else, have any questions or comments? Thank you all again very, very much. Let's see, we'll move on to the next agenda item, which is the update on modification of elimination of bias in CLE rules. And let's see, Senior Program Analyst Erica Carroll, you're going to take that one.
So the working group for MCLE is Judge Esther and Connie. And the objective that the MCLE working group is working on is to, by December 31st, 2020, modify the elimination of bias curriculum contained in the MCLE requirements to consider creation of subtopics and expanding the number of required hours. So the 2 major initiatives under that objective are to make some changes to the proposed MCLE rules and create an e-learning course focused on elimination of bias. So at the last COAF meeting in February, the proposed rule changes were brought to COAF, and COAF made a recommendation to take them to the Board of Trustees to be put out for public comment. And just to recap what those changes are, it would increase the elimination of bias hours for attorneys from 1 to 2 hours over the course of 3 years, and have at least one of those hours devoted to the topic of implicit bias. It also proposes changes for MCLE providers in order to meet the new requirements of AB 242, which implemented a new statute, Business and Professions Code 6070.5. And so providers who offer implicit bias courses will have to meet certain training and education requirements and incorporate components on explicit bias, implicit bias, and systemic bias in their courses, as well as provide actionable steps for attendees as part of the curriculum for implicit bias courses. And so those proposed changes were taken to the board in March and put out for public comment. The public comment period ran from mid-March through the end of June. And we received 31 comments in response to these proposed changes. All of the comments that we received were in relation to the attorney rules. There were no comments related to the changes proposed for providers. So of those 31 comments, approximately 60% were in favor of making these changes. In addition to individuals who commented, we received 4 comments from organizations, and those were the California Commission on Access to Justice, California Lawyers Association, California Minority Counsel Program, and the Legal Aid Association of California, and they were all in favor of the changes. Many of the comments broadly were in favor felt that this would help with increasing diversity and inclusion in the legal profession. They felt that there would be increased awareness and tools to mitigate bias, that it would enhance the credibility and fairness of the legal system. And then there were a number of comments that asked the State Bar to consider going further in making changes to the MCLE rules. And those were mostly related to creating an anti-racism requirement that addresses structural racism, asking for more hours. So the current proposal would go from 1 to 2 hours, but asking for an even larger increase in the hours devoted to elimination of bias. One comment asked for consideration of renaming the requirement. Currently, it's recognition and elimination of bias in the legal profession. This commenter felt that it would be clearer in terms of what's trying to be achieved by renaming the requirement and being specific and saying that it's the recognition and elimination of structural racism and implicit bias in the legal profession. And then there was also comments related to having this MCLE credit in a participatory setting. And so the way the MCLE credits are structured, attorneys have to complete 25 hours every 3 years. Up to half of those credits can be done in what's called self-study. Participatory setting can either be an in-person requirement or it can be done over the internet, but in something like a webinar or an online course. And so there was a recommendation to make the elimination of bias credits specifically a participatory setting, which is not a requirement currently. So. The comments that were opposed to the rules changes centered on the themes of attorneys wanting to focus more on their practice area, not wanting additional credits in other topics. Some attorneys just felt MCLE in general, regardless of the topic, was unhelpful, or said that their specific experience with prior elimination of bias courses had been not useful to them. And then there were a couple comments that in general said that the attorneys felt that they didn't believe implicit bias existed or that there was anything that could be done about it. Just some observations in response to these comments from comments that were opposed to the changes. As I mentioned, there's the MCLE requirements are 25 hours over 3 years. The only requirements that are not general credit are 4 hours of legal ethics, 1 hour of competence, and 1 hour of elimination of bias. And now the proposal is to increase that to 2. So by and large, the majority of MCLE time is already devoted to general credit, where attorneys can focus on their practice area. And there is certainly no limit to them going beyond the 25 hours if they want further education in their practice area. This is a fairly modest increase. And for the attorneys that felt that MCLE was unhelpful or that elimination of bias in general was unhelpful to them when they've taken those courses, the hope from the State Bar's perspective is that with these new requirements being added, especially for providers, giving them guidance on content and course outcomes, that this will improve the experience in taking elimination of bias courses and that it will have measurable outcomes across the profession. And then for the commenters who denied the existence of implicit bias, there is clearly a substantial body of research about implicit bias and its effects. And so, you know, the working group felt that the comments that were opposed were outweighed by all of the benefits that will be rendered by making these proposed changes. And the recommendation would be to take this back to the Board of Trustees at their next meeting. They have a meeting coming up in September, and to recommend that the board adopt the changes without any amendment to the proposed rules. The one caveat being, we are asking both that COAF make the recommendation to take it to the board, but also approve an alternative motion. The reason being, and you may have noticed it in the memo, is that there was basically a typo in the statute, the new statute, Business and Professions Code 6070.5, about when the implicit bias course would be required for attorneys. It was intended to apply to those reporting in 2023, But the way that the statute is worded, it has the effect of applying to attorneys reporting in 2024. There's currently a bill pending, AB 3364, to correct that, and that would make the effective date 2023. And so we're recommending that COAF recommend the board adopt the changes as is without any change except for, in the event that this bill is passed, change the effective date to 2023. And then as far as the other comments that came in favor of the rules changes, but asking, COAF and the State Bar to consider making additional changes and going further with the elimination of bias requirement, that is certainly something that can be discussed and taken up. But given that none of those suggestions are in conflict with what's being proposed currently, the recommendation is to move forward with this piece and then turn to some of those other suggestions subsequently.
So Erica, this is an action item and I want to be clear in terms of what you're asking us to do so that someone will be making a motion. So you want us to recommend that the BOT approve it in September and with the understanding, if there's a law that's in effect, it's going to have to be complied with anyway. So I'm not sure how you want the alternative part of it to be worded in the motion. So you want the recommendations to be taken to the BOT, but you also want, as part of that recommendation, that they comply with AB 3364 if it passes?
Yes, I think the way we had thought about it was that it would essentially be two motions, have an alternative motion to give staff the flexibility that because this AB 3364 has been brought forward during this legislative session, which is ending next week, I think.
Yes.
So we will know by next week whether it passes or not. So we will know before, yes, the September meeting, whether that change needs to be made. And I agree, if that's the law, it'll have to change. But in order to not have to bring that back later to make the date change, that the recommendation would be to bring the proposed rules to the Board of Trustees as is, but in the event that AB 3364 is passed before the next meeting, that staff would propose the rules with that one amendment to the date.
So Erica, we anticipate just forwarding the Board of Trustees in September with just one recommendation, while we're putting the motion in two separate votes, just for purposes of, since we're not meeting until December. Ultimately, what's going to go to the board is one of two things, which is compliance date by 2023 or 2024.
Right.
Right. I'm thinking then, I don't know that we really need to put in anything about AB 3364. Because if it has passed by the time the board meets anyway, and they know it's going to be effective, they can make the amendment to any motion. The staff memo can make any request for amendment. So I think that what we do, perhaps the cleanest, is simply to approve the recommendations. And then if by the time staff writes its memo for the September board meeting, AB 3364 has passed, then staff can recommend that they tweak the language so to reflect the correct date. Can we do that? So I think that what we do is just recommend approval of the recommendations as they stand, and then it's up to staff to bring to the attention of the board whether that recommendation needs to be tweaked in any way. Elizabeth, you have any? Does that seem like, that seems to me to be a cleaner way to do it rather than having two recommendations or alternative recommendations?
I think that's fine. Do you feel comfortable with that, Erica?
Yeah.
Okay.
Okay. All right. Well, let's do that then. So then what we'll need to do, the motion then is to recommend approval of the proposed changes at the board meeting in September.
And I so
And
move.
I will entertain a motion to that effect.
And this is Esther. I so move.
This
Right,
is
we need-
Ryan, second.
Okay. Any further discussion? If not, Elizabeth, I made a big note to myself. Can you please take a roll call vote?
Yes. Judge Brenda,
Aye.
Judge Esther,
Aye.
Heather,
Aye.
Connie, Ryan,
Aye.
Genevieve,
Aye.
Emily, Kristen,
Aye.
Donna,
Aye.
Sal. Motion carries.
All right, great. Thank you. And if there's nothing else on that agenda item that we need to take care of, we'll move to the next one. Thank you. Thank you, Erica.
I just wanted to give a brief update as well on the
Okay.
e-learning course. The board did approve moving forward with developing an e-learning course, and so I just wanted to thank those who have made suggestions for content experts. We are reaching out to them actively and are in discussions with some of them. So hopefully by the next meeting, we'll have something more concrete to present. And then we're also looking into vendors for the design portion of the course. So,
Okay.
thanks.
All right. Thank you. Anything else from you, Erica? Not? All right. Thank you very much. Next is the update on the early pipeline to the profession outreach materials. And the first is an update on the Want to Be a Lawyer brochure. And Judge Christian, you're going to handle that.
I am. And I just want to say that although Sal's name does not appear on this beginning of the slide, Sal worked hard on this project with me. And if he'd been here, I would have made him present. So this project is one of the pipeline projects that we have going on that meets the goal 4 objective to our strategic plan, and that's to get more diverse attorneys into the legal profession and keep them there. Many of you may have remember seeing the old brochure, which was titled "Want to Be a Lawyer?" ? Which we agreed on as part of the group was not a great title. So one of the many things that we have done in updating this and is to change the title. And if Erica, if you're managing this, perfect. So we've now titled it "Be a Lawyer, Make a Difference." One of the reasons that we changed the title was because if you answered the question, no, I don't want to be a lawyer, you didn't have to read the brochure. And in this one, we're trying to speak to what we know a younger, new generation what wants to see, and we know from multiple surveys and reports that young people, especially young, diverse high school students, college students, are looking at the profession of law as a way of making a difference both in their community and within the country and globally. So we changed it now to "Be a Lawyer, Make a Difference," and the brochure itself, when it's done, will reflect that. It's intended to be a leave behind brochure, but there will also be an electronic version on the State Bar's website, also to speak to a younger group of people who spend more time online. We've changed the language to be more dynamic and more street law language, again, to speak to that group that we're looking at in the pipeline: high school, community college students who we really want to get into the profession. One of the biggest things that we did was update and change the role models. Not that the role models that were on there from 15, 20 years ago weren't great. But we have updated the role models to speak to, again, a younger generation. Some of the role models will be people that folks are already familiar with. David Kelly, who I think we're going to probably talk about after this as part of the video project, who is the general counsel for the Golden State Warriors, is on our brochure, as is Justice Kantil Sakayui. She will be featured in this brochure. There are a number of other people, Lisa Cisneros, who's an LGBT activist, Alexander Chen, who co-founded the National Trans Bar, Alicia Valencia, who is active in the Hispanic Bar. These are all people who will be featured on the brochure. And the electronic brochure, we hope that we'll have a clickable link where you can learn even more about the individuals. Of course, it's just a short blurb about them on the brochure itself. But we worked hard to secure a diverse group of people with a diverse group of experiences in current jobs. We've also updated what lawyers do to be a little more sexy and relatable. So we talk about in there that lawyers help people achieve citizenship. They protect people's constitutional rights, negotiating contracts for musicians, artists, athletes, those kinds of things that that are the types of careers that might encourage young people to choose a career in the law. And then we talk about ways to bring legal education within reach. So we talk about, we're going to talk about and have resources, both ABA accredited law schools and then the California accredited and registered schools. We're going to talk about ways to fund, there are going to be resources that help you fund law school, which as you all heard me say earlier, is a big issue for me as well. And then we're going to have the links, the QR codes with new updated resources for folks to take a look at if they want more information. And yeah, so we are now actually in the phase where we've collected the role model photos and biographies for all of the folks that'll be in there. And State Bar staff is working very hard, probably as we speak, with the designers to redraft the brochure. And it's going to be published, it says as soon as possible, and it'll certainly probably be maybe even in the next month. So I know that Dan Pasamanek, who is not here, has been working hard on it for the State Bar. And then, as I said, Sal and I spent a lot of time working on this. So hopefully it will be updated and it will speak to more people.
Thank you, Judge Kristen. Any comments or questions?
I just want to, I'm so impressed and so excited. I can't wait for this to come out. This is awesome, awesome, awesome. So great job. Thank you so much. I can't wait to like distribute it everywhere.
Yeah, it really does look good.
Yeah.
And you know,
anything else? Well, I want to thank you, Kristen, and your work group, everybody who worked on it. This is, I'm just so thrilled. This is so exciting. And we are moving on with it as well. I mean, we got our work plan expanded and approved a couple months ago. This was one of the things we wanted to do so that we could expand our pipeline to the high school level. And we're doing it. So I can't wait to see it. I can't wait to see it. All right. Thank you. Anything else, any other comments on this before we move to the next agenda item? This is great, exciting. Okay, the next is the update on the attorney video project. And Ryan, you're gonna take that part of it.
Yes, and I think Erica Carroll has the reins on the presentation. There we go.
Okay.
All right, so this is the video project. This also falls under Goal 4 Objective L. And the members of this working group include Pat Lee, Heather, Judge Brenda, Elizabeth, and I. And we are in the process of going ahead and moving on with our first plan to interview David Kelly, who's the general counsel of the Golden Warriors. And he is quite a person. I actually met him when I was in law school at a Black Law Students Association event, and from that grew a professional relationship. And I think Judge Brenda knows him as well. I spent some time actually in-house with the Golden State Warriors in 2015 when they won the championship, which was quite an experience. And so David Kelly, he's going to talk about his non-traditional role as a general counsel of a sports franchise, which would certainly appeal to high school students now that we have the green light on targeting them with the diversity pipeline so that we can encourage them to be attorneys. Can you go to the next slide, please? And so that will be the purpose of the video, is to really connect with that demographic of people, to spark their desire in becoming attorneys by showing them different kinds of attorneys that do interesting things. And David Kelly's certainly among them. Go to the next slide, please. And so our plan is to record an interview. Heather and I worked on some questions, and the questions really cover a broad category of things. So we're going to be narrowing them down, but generally speaking, we want to talk about his history, what it was like for him growing up. When did he want to become a lawyer? Why? Did he play sports? Things that high school students are interested in, and other things too that generally high school students have to deal with on a daily basis, which is the fear of failure, the fear of being different or of being the same, self-doubt and self-confidence. Also, what hard work looks like and actually feels like. Also, things like situational envy, fear of growth, the difference between your dreams and goals, questions that really kind of dig deep, that can resonate for youth, are the things that we want to really get out of Mr. Kelly. And I think we can do that. Heather and I are going to be the two individuals interviewing him. And right now, we don't know whether or not we're going to be able to interview him in person or through a platform like Zoom. The preference is certainly in person, but we plan on meeting with David Kelly remotely in the near future to iron out the logistics for this. Go to the next slide, please. Oh, that's it. Okay, so that's pretty much what's going on with this project. If anyone has any questions, I'm happy to answer them.
Any questions or comments for Ryan? This is another cause for a huge celebration for me, for COAF. This is something that we really wanted to do and that we got approval to do the last couple of months, the past few months. And so we are moving on it. David's going to be great. He's going to be a real inspiration and role model. So I thank everyone for that. Esther will be working on it and has been involved in CLA, the CLA liaison as well. Ken has been involved on it in it as well. So we'll be moving on, and I can't wait to see it after I'm gone and everything. So everybody, let's give everybody a hand for that one, that project as well as the Want to Be a Lawyer brochure. Excellent, excellent, excellent. Okay, now let's talk about the review and discussion of the final 2016 Judicial Diversity Summit report. I'm going to take the lead on that one. And you have attached to your, or linked to your agenda item, the summit report. And there really, it was referred over to COAF to see if there are any recommendations that we should be making to the Board of Trustees for any action, which, as you know, we really can't take any action because we can only do things on judicial diversity if it's requested by the Judicial Council, and the Judicial Council is going to be taking the lead on judicial diversity matters, the Judicial Council and California Lawyers Association. But I would like, if you're able to pull that up, attachment A to the Judicial Diversity Summit report, just on page 29 of that report, it begins a work plan. That work plan was, or rather an action plan, it was recommended before COAF's involvement in judicial diversity was limited. So yes, go to page 20, 28 and 29. I just want to give an update on something that's really important and that is also very thrilling for us, and we're going to take credit for having accomplished it. And that is on page 29. One of the recommendations would have been that on just the one, judicial appointments and elections, that said, encourage the governor's office to have the JSAC members undergo training on implicit bias. And the judicial appointment secretary, the current judicial appointment secretary, Justice Martin Jenkins, has had all of his JSAC members undergo an incredible implicit bias training program. But that is something that we wanted. We tried for all of the years of Brown's term to get his JSAC, what used to be called the secret committees, the judicial selection advisory committees. We tried very hard to get Governor Brown to have his JSAC members undergo, and he didn't. But Justice Martin Jenkins did do that. The next part of that would be, which will be up to CLA and the Judicial Council, will be to try to see if the county bars will have their judicial evaluations committee members undergo mandatory implicit bias training. So that's one of the good things, but there's really nothing that we can do on any of this except see if to the extent that the Judicial Council takes some action, if they ask as COAF for some assistance. The other thing I'll point out to you in terms of highlights is if you look at pages 27 and 28 in the report, kind of gives you a comparative analysis, some slides of where we started out in 2006 when we first had the first Summit on Judicial Diversity, and where we ended up basically at the end of 2019, which is when the official stats are available. So it looks at ethnic diversity, looks at gender diversity, and it also looks at other diversity, including LGBTQI and disability and veterans. So those bar graphs also give you an idea of the progress that's been made. So, but we are really accepting the report. The state bar has already accepted it, referred it over to us, but I don't really think that there's anything that we can do with any of the recommendations or with the work plan, the action plan rather. So unless there are some questions, it was really good. We were behind. The summit occurred in 2016. COAF was to have the chair of the summit planning committee, who's a former chair of COAF, and other COAF members. It didn't get, the final report did not get written until just now. I want to thank Pat Lee for her assistance in this. Pat's just always been such a workhorse. And she and I took the laboring oar in terms of really just trying to get this report done. It's like, we got to finalize it. The next Judicial Diversity Summit is next year in 2021. They occur every 5 years. So we've gotten it. California Lawyers Association has been sent a copy of the summit report, and they will decide what recommendations they will implement. The Judicial Council has also been sent a copy of the summit report, the final report and recommendations, and the Judicial Council will decide what they will do in terms of judicial diversity. Thankfully, we do have a wonderful liaison. If Judge Yu is still on the phone, and she was in on the ground floor of the summits, so perhaps as a liaison from the Judicial Council to COAF, she can also keep us apprised of what kinds of things the Judicial Council might do, and maybe she might even suggest that the Committee on Providing Access and Fairness engage in some of the things that we think will continue to diversify the profession, diversify the judiciary rather. So any questions or anything from anyone? So that is it. And every thank you also goes obviously to staff, to Elizabeth for all the hard work in getting this finally done, and all the editing and everything else. I really appreciate it. Okay, next item, review and discussion, the update on Judicial Council requests for assistance on judicial diversity initiatives. Really nothing to update us on, to update you on. We don't have, sometimes we will participate in any judicial appointments workshops that the Judicial Council does, but we have not, we've not been requested to do any. We're not sure whether there are any planned, and perhaps Judge, you might be able to find out for the next meeting whether or not there's any kind of schedule for these judicial appointments workshops. They still need to be done. COAF did a number of them when COAF was taking the lead on judicial diversity issues. I'm not sure when the last one was done by the Judicial Council. I know there was one that was done in December because I was on the panel for that one, but I don't know if they've done any more. But we'll be available if they ask for assistance on that. But it is critical and crucial that those workshops be done. Some of the courts are doing it.
Yes, I know that the Providing Access and Fairness Committee is doing them, and I can get a schedule.
Okay, excellent, excellent, excellent. That is great.
And Judge, the one thing last year under Governor Brown's, when Josh was the appointments person, and he would meet regularly with COAF when we were doing the appointments workshops. And one of the things he stressed was that those workshops should happen in the counties where there are vacancies and where there's not that much diversity, so that you do a workshop in that county to try to recruit more attorneys from diverse backgrounds to apply for appointments to the judicial position, so that the governor has a broader pool from which to choose.
Okay, made a note of it. Thank you.
Okay,
Pat.
thanks.
All right. Okay, if nothing more on that, we will move on. And if no questions or comments on that, we'll move on to the next agenda item, which is an update. Which is a discussion of additional diversity and inclusion initiatives. And this aspect of the agenda is really, I mean, nothing's agendized, so we can't take any action on anything, but we use this part of the agenda to talk about perhaps some new ideas, initiatives, strategies, things that we should perhaps think about doing and bringing back to COAF on a regularly noticed agenda. And I'm going to ask, one thing I'm going to do is I want Elizabeth first to talk about the biannual report, and then we'll open it up to any other discussion. So Elizabeth, go ahead.
Thanks, Judge Brenda. So I wanted to remind COAF members that per Business and Professions Code 6001.3, we submit a biennial, so every 2 years, report to the legislature, reporting on the diversity and inclusion initiatives and activities that the State Bar has been engaging in, as well as putting forth like a 2-year plan. And so we definitely want, I want to take this opportunity for COAF to think about, what recommendations to staff to include in the 2-year plan. A lot of the things that COAF is working on was in the plan that was submitted in 2019. And so the next report is due in 2021. And so I think it's a really great opportunity to report back to the legislature the progress we've made, but also to let them know what we plan to do in the next 2 years. And so my suggestion is that I work with Judge Esther and Ryan as the incoming chair and vice chair to kind of flesh out some additional details for this biennial report, but obviously want to open it up to all of COAF to start this discussion. The report is due in March, so we would all have another opportunity in December to just discuss further, but I think if I could, check in with Judge Esther and Ryan in the interim, that would, I think, would really be helpful in guiding the conversation.
Okay. And so you don't need anything from the group today?
No, I mean, I think we had actually a pretty good discussion earlier today with Bonafide, but if there are any additional items, one of the ways that the State Bar has been looking at diversity, equity, and inclusion is that it is built in, not bolted on, which, as you can tell from our work plan and the strategic and in COAF's work plan and also in the strategic plan, that, the diversity, equity, and inclusion work does not just live in the Office of Access and Inclusion and does not just live with COAF, but is, infiltrated throughout the bar. We had, OCTC come speak with us today. We're working with the Office of Admissions on various items. So we're really trying to make sure that, diversity and inclusion are just kind of in the fabric of the work of the State Bar. And so, the feedback and input that COAF has to that really makes a difference and is really influential. And so I would encourage everybody to think about what we can continue to be doing in the next 2 years and beyond, and include that in our upcoming report.
Okay.
All
right.
What the current contribution by attorneys to the elimination of bias spend is $2 per year right now?
I believe that's correct.
It's
Okay.
going to be 2 hours, yes.
$2?
And I
So-
did want to bring up a topic that's kind of related to that. I know in our recommendation for the MCLE working group, one of the things that the bigger organization had recommended was maybe even having more hours of elimination of bias, or focusing on a little bit more on, anti-racism, what have you, maybe requiring additional hours. So maybe this can be something that we can consider as part of the current work plan under MCLE. But Pat Lee actually sent me this incredible article that said, let's create an ethical obligation for attorneys to fight racism. And this is in line with the American Bar Association's proposed model rule, where they suggest requiring attorneys to devote at least 20 hours a year.
Well, it was aspirational, it wasn't required.
Aspirational, right? and not one of the requirements, but aspirational, just like the 50 hours of pro bono services. In increasing diversity, and that could be whether you're volunteering at organizations, or, we kind of talked about this with Banafsheh as well, maybe collaborating with others, maybe allowing opportunities for students to get involved in nonprofit organizations. But, maybe that's something that we can expand a little more in our MCLE group to have some discussions on whether or not we should also propose a rule that kind of follows the ABA model rule recommendation of the additional 20 hours specifically devoted to diversity, inclusion, and equality work. And I think especially now in these times, if the State Bar took an affirmative role to say, let's make it an ethical duty to fight racism, I think that would be extremely powerful. And that would certainly be something that I think, since we've had such great kind of comments coming from the public for the MCLE, I just kind of see that as a natural maybe progression to something that we can focus on. But I wanted to get everybody's thoughts.
That's great. That's great. Any thoughts, comments, or anything? That's a great idea, Judge.
And I'm happy to forward the articles that Pat sent me. I mean, they are really compelling. So I'm happy to put that to the COAF board before our next meeting, so that we can maybe have some further discussions on that.
And if you want the person who wrote them, Mr. Douglas, he's on one of our ABA committees currently, and he's very passionate about this. If you want him to even present the whole concept and rationale to you all, so that you know what he's trying to push for here, we could probably get him to attend the meeting as a guest to give that presentation. Yeah, and basically it's an ethical obligation to promote diversity in the profession and equality in society. And
Please forward to me. Yeah.
And it's obviously appropriate at this point in time with what's happening.
Yeah.
And the justification he provides in those articles is really compelling. What I was going to say is we should also push for an increase in the $2, because with all the work that's going on, I mean, we didn't, in the report that went to the legislature, the budgeting wasn't broken down, so we don't know exactly how much money is spent. But with the mandate, with the legislative mandate to focus on access and inclusion, we had and Brady, you should be able to find this in the Office of General Counsel. Our liaison before you helped us to analyze the COAF work plan, and General Counsel recommended that at least half of the activity could be funded by the general fund. But the more you could get donated to the Elimination of Bias Fund, you'd have more money there. And then also with the mandated legislative mandate to focus on inclusion and access issues, you have less of a chance of getting sued. But if you do, you have a greater chance of trying to overcome Keller and Browster House.
Very good. Other comments? Yes, Kristen.
This also sort of piggybacks on what Judge Esther was just saying about the training that we're having people do. I'm doing judicial education work with some of the other organizations that I'm involved in. And one of the things that we've talked about around implicit bias training is this idea that people go to implicit bias training and then and then it's over. And there's no, and that the training sort of stops at this idea of, you know, here's your implicit bias and you should spend time recognizing it. And then when they're done, folks are unable to sort of transfer that outside of that training. And you see this in, you know, you see this in Milwaukee where those police officers had just attended, you know, bias training, and then, you know, a week later, you know, the George Floyd murder happens. So, you know, that we need to be linking our training in a more meaningful way, that we need to be doing training in a way that actually changes behavior and doesn't just check a box for folks. And really looking at what we're doing. And Judge Brenda, I think you brought this up, you know, who is doing the training, and what is the curriculum, and is it enough? And and should there be a part 2 that pushes it forward?
Great. Any other comments or questions or anything?
This is Pat, and this came up when we were doing the Jenny training, the implicit bias training. You're right, there needs to be more than just one standard training, because after you've seen the one and you're still required to do more, you don't want to see the same one again. So you're going to have to keep continuing to create different approaches to the training, which means you have to find experienced trainers who are able to do quality training. And it's really hard. It's really hard to find the trainers that are able to do that, because there are a lot more people now supposedly doing implicit bias training, but they're not all that good.
Right.
Mm-hmm. Okay. All right. Okay. Well, this was great. Excellent idea, Judge Kim. Thank you. Thank you for raising that. Anything else on this sort of like an open forum kind of thing? Anything else that we need to discuss today? And you'll have an opportunity to provide more input. Yes.
So about kind of creating a situation where it goes beyond training and kind of starts to impact people's actions to advance the racial justice issue. You know, I'm just going to throw this out there off the top of my head, but maybe we can create like some type of rule, like if you're an officer of the court, you can't be going around in society saying reprehensible things, like incredibly reprehensible things, maybe that could impact maybe an issue with your state bar license or something like that. I mean, that might be seen as extreme on one hand, or maybe a violation of the First Amendment on another, but I mean, maybe we should take a look at that. And the reason why I thought of that is because of another issue involving a different situation, like for example, what's going on in the city of Vallejo, where law enforcement officers have created a culture around killing civilians. They literally advocate for the killing of civilians when an officer has a duty homicide. They throw a barbecue for that officer. They celebrate it, and then they bend the officer's badge ever so slightly at the 3 o'clock tip of the star. If the officer has more than one body, they bend it at the 4 o'clock tip of the star. And this has become ingrained in the culture of that agency to where other officers jump at the opportunity to kill. And so in this situation, I've reached out to a couple members in our legislature to maybe amend the law governing incitement to riot, to include a prohibition on officers openly advocating the killing of civilians and getting rid of the immediate harm requirement, making that a misdemeanor. Things like that might work because obviously training doesn't seem to be that impactful. And so obviously this is a discussion that needs to be had later, but I wanted to throw that out there.
That's an idea. That is a great idea. We can look to see whether or not we can put something in the ethical rules. That's great. Excellent. Yeah, the current with the law enforcement aspects of it, there are also studies that have been released and tracking that's been done that says that that basically our police departments are being are providing attractive havens for white supremacists and people, so that they are moving more and more into the police departments around the nation. So there are groups that are tracking that, and the violence that comes with that is frightening. But so we will see what we can do from our end as a regulatory agency to make sure. Some of the posts, I'm sure, you have First Amendment issues, but to the extent that lawyers may be encouraging violence or inciting violence or posting things that are racist or sexist or homophobic, perhaps there ought to be some consequences for those kinds of things when or if it occurs. So, okay, very good. Any other thoughts? Ideas?
Hand raised.
And on the topic of training, I think it's been a while, but I know that it has been helpful for lawyers to have training from people who are on the Commission on Judicial Performance, because officers often display bias or make certain comments. And I think a lot of times lawyers don't know that they can make a confidential complaint to the commission. And I have participated and others have participated that we have a whole when I was on it, we had a whole PowerPoint on various different examples from real life of what judges had said and what lawyers could do to report that judge because it is misconduct. And actually on the commission website is a compendium that anyone can look at that sets out all the discipline any California bench officer has received from the Superior Court or appellate courts from 1960 to the present, where the conduct arose from bias. So I think sometimes that empowers the lawyers to understand that they don't just have to sit there and listen to the judge make comments. And having been on it for 9 years, I saw every discipline complaint against every bench officer in the state for 9 years, and there's a lot of complaints of bias. And some of that actually leads to judges being removed or publicly disciplined. So that might be something in terms of training to empower lawyers.
That's great. That is great. That's excellent. And by the way, does the State Bar issue any annual discipline reports? Does it say, your 2019, we discipline so many we disbarred?
I believe there is an annual discipline report.
Okay, all right.
There's
and is it
it's on the
broken out?
website. We actually, if you go to the website and just to type in the search bar reports, all the reports as they're published are listed on the screen.
Does it break it down by race or gender? I mean, I know that the Commission on Judicial Performance doesn't do that either, but does it break it down by race or gender or by practice area, anything?
That I do not know off the top of my head.
Okay, all right.
CJP has a 20-year survey of discipline that was done by Professor Joe Nation of Stanford. It's now old, but it did look at discipline where women was like gender was an issue and years on the bench. And interesting, women were disciplined, although they may have received an equal number of complaints per capita or more, female judges received discipline less than male. And I think there's a lot of factors that go into that because of how we communicate with people as women and things like that.
Yeah.
And then
Very
also
good.
there were a lot of sex-related complaints that until recently in Texas, there weren't really any female judges who were accused of misconduct because they were having sex with court personnel. So that was like, I think, another reason why males were disciplined more than females as bench officers.
Interesting. Interesting. Thank you. Okay, if nothing else on that, we'll move to the final agenda item before adjournment, and that is to receive reports from liaisons if anyone has any. And I can turn first. Well, is Ken Wang on yet from CLA, from California Lawyers Association?
Yes, I see Ken. Ken, you're mute. Okay, there you
Yeah,
go.
sorry, Judge Brenda, I'm here. Sorry, I had to attend the
Hi.
meeting this morning.
No problem.
Yeah, as we all attended the CLA Zoom call last week, CLA is very interested in producing its own short videos, profiling attorneys who are making a difference, and on the diversity issues. So we brainstorm on ideas as to who could be profiled. So that's what we talked about during our last Zoom meeting. So yeah, I think it would be a great transition to have the CLA produce short videos in the future. Other than that, that's all I had to report.
All right, great. And we had talked about whether or not, how many videos COAF might be able to do. Heather has an idea of trying to do one with Disney. So we'll figure out whether we have to go back to the Board of Trustees for COAF to do another one, or whether or not we have to give it over to all of the rest of the videos over to CLA or joint project or whatever. But we'll talk about that. But thank you very much, Ken. Any questions or anything from Ken? And then just in terms of CLA, they are planning the 2021 Summit on Judicial Diversity. And I'm on that planning committee. Pat's on. I think Esther will probably soon be on it. I am serving as the COAF liaison to that planning committee. Their DOC committee. Okay, all right. With respect to California law, Pat, anything from you?
Yeah, we've been going through restructuring, so there's a lot of things that we're going to be planning. And I mean, for the new members and liaisons that weren't here last time, California Law's mission is to establish a pipeline of diverse students from high schools, community colleges, four-year institutions, and law schools into law or law-related careers so that the legal profession reflects the diverse population of the state of California. Cal Law is now a fiscally sponsored program under the Foundation for California Community Colleges, which is the auxiliary nonprofit for the California Community College Chancellor's Office. Cal Law, we serve as the foundational structure that connects, communicates, collaborates, and coordinates with currently 21 high school law academies that have been created under the Education Code Partnership Academy model. They receive state funding, and oversight is provided by the California Department of Education. California Law also supports members of the remaining 2+2+3 pathway, which includes 29 community colleges, 9 law schools, and their respective undergraduate institutions. Those partners sign an official MOU, which has specific requirements and responsibilities for each of them, as well as a required community college curriculum that reflects the courses based on a defined set of success factors, tracking the Schultz-Zedeck 26 factors for effective lawyering. With restructuring, we now only have 3 committees: Executive, Finance, Outreach Committee, and Program Committee. And I chair the Program Committee, so we've come up with a long list of things that we're planning to do or in the process of doing. We provide program development and technical assistance for each of the high school, community colleges, 4 years, and law school partners. Ensure that the MOU requirements are followed. We collect data on metrics and facilitate discussions on best practices and improvements. We provide certificates to participating community college students who successfully complete the Pathway program. And thanks to the State Bar for issuing the State Bar certificates as well. That was really important to the community colleges and the students. Also, we're working on developing and maintaining a database that tracks the students transitioning along the law pathway. And we'll be meeting with the Department of Education and the Community College Chancellor's Office, as well as the undergrad and law schools, to find out what data sources they have and how we can retrieve that data and combine it into a full data reporting system that tracks the students. September or February 17th to 19th next year, we'll be holding our annual Pathway to Law Summit. It'll be a 3-day virtual format, and I'll give you more information on that during the next meeting. We're coordinating our annual Law Day celebration during the month of May 2021, and we'll be using the ABA Law Day theme, Advancing the Rule of Law Now. We'll be presenting a Constitution Day celebration on September 17th, the theme being Black Lives Matter and the U.S. Constitution. And the two speakers are Dean Erwin Chemerinsky and Paul Henderson, who's the director of the current San Francisco Department of Police Accountability. We'll be convening monthly forums for the high school teams, as well as the rest of the Pathway partners, to maintain communication on key issues, challenges, and California law updates. We'll be creating a speakers bureau in partnership with California CLA, as well as looking at key topics that CLA can help us recruit speakers on. And the first area being Know Your Rights, which provides information on student rights and responsibilities when they encounter law enforcement. And as Judge Brenda said, we're working and partnering on the Judicial Summit planning with CLA. And as Ken and Ryan mentioned, we're partnering with COAF and CLA on the videos that are being created. So that's it.
Okay. Thank you very much. Any questions for Pat or comments?
If
Thanks,
anyone
Pat.
wants help planning, let me know on any of those projects.
All right. Very good. Thanks, Pat. And now for the Judicial Council Liaison Report, Judge Erica.
Well, I emailed the Judicial Council staff for PATH to find out what the schedule is. I don't have a report for the council, but I can report for the California Access to Justice Commission. We started a new committee that is a Racial Justice and Intersectionality Committee, which is chaired by myself and Panita Ronca. We are planning a symposium for September 25th. And it's called basically, let's see, After the Moratorium, Balancing the Equities in Unlawful Detainer Cases Through an Anti-Racist Lens. Our keynote speaker is going to be Mr. Terrence Roberts, who is one of the Little Rock Nine, and he's going to talk about his experience in housing. We also have legal services attorneys who will talk about sort of what they anticipate the needs will be of their clients and some client testimonials. And then I really agree with what Judge Rosie said, that it's not just checking a box or having somebody listen to a keynote. It's about sort of how does that translate. So the intended audience is bench officers and court staff, because we want them to be able to see. I know everyone's feeling stressed out about this anticipated onslaught of evictions, but we want the bench officers and court staff to be able to see the litigants and understand their stories and where they're coming from. So either the second segment, depending on how much time we need for the first, or the second half of this symposium will be a training by Judge Mark Uhas, who chairs or is a co-chair of the Access to Justice Commission, myself, and then Bonnie Huff, whom many of you know, about what skills bench officers and staff should bring to bear to ensure that we are giving people the best experience in the courtroom, treating them with respect, and that it is in an anti-racist way. So that's one thing that the commission is working on.
All right.
I'll have more to report about the council next time.
Just Brenda.
Yes, there's a comment. Yes.
I just want
Ryan.
to comment because I always bring this up whenever the Little Rock Nine is mentioned.
Yes.
My grandmother, who was married to a Tuskegee Airman and at the time stationed in Little Rock, drove the Little Rock Nine to the high school they integrated. She was among a team of parents.
Oh, wow.
So, yeah, she said she had to drive through mobs of people throwing bricks and all that kind of stuff. And so it was quite a valiant effort.
She should be a speaker too. And I mean, it would be wonderful to hear from her at some time.
Yeah, unfortunately, she passed away from COVID.
From COVID. All right.
Oh, Ryan, I'm so sorry.
Oh,
Ryan.
Terrible.
Thank you.
I'm so sorry. Yeah.
Yeah.
Wow.
Well, I'm sure you make her proud, and you're a living legacy to her in all her efforts.
Thank you.
Yes, indeed. Wow. Any other comments, Heather? You kind of like what you're hearing, huh?
Always.
All of these initiatives. I mean, it's amazing. We are really, really pleased that the board agreed to let us have liaisons to other groups so that we can know what other diversity, equity, and inclusion initiatives are going on or happening with other groups. So this is wonderful. This is outstanding. Yes, and again too with Erica with PATH, with the Judicial Council's committee on providing advisory committee, I guess, on providing access and fairness, whatever kinds of things initiatives they have going and stuff and things that they're doing, we can hear about those along the way and at the next meeting. I do know that I guess the Judicial Council did the training for the Ginny Commission. They did the training. When was that, Elizabeth? On judicial diversity. Was that was sometime this year, February or March or something, right? That Kathy Ongiri.
Sorry, this year is, the time is weird this year. So yes, February.
I'm sorry. It was in February?
I think so, yes.
Okay, then, all right. So they did Ginny training in terms of judicial diversity, the stats and everything, but we're not sure what the rest of that implicit bias training was. I'd actually did I ask already for the curriculum for implicit bias for the Ginny commissioners? I would like to know what the curriculum is, and so that we can see specifically what training they have gotten. I do know that it was I don't know who the presenter is. I think that the JSACs, the Governor's Judicial Selection Advisory Committees, their training was done, I think, by maybe the Associate Dean or something at UC Irvine or something like that, who was just phenomenal. I mean, all of those, the JSAC members that I talked to just said, it was just the most incredible training that they had ever been through. So it would be good if we can make sure that all of these people making important decisions about judicial appointments, COAF can't do anything, but we can talk. But it would be good to make sure that there's some uniform training because the same issues that JSAC, the JSAC members are facing would be the same issues that Ginny Commission is, to the extent that there are stereotypes and others. One stereotype is like the angry Black woman. I mean, how do you filter comments, negative comments, when you're evaluating someone? How much weight do you give when you have someone saying, well, she's hard to get along with, she's mad, she says things, but in any event, it would be really good to have some uniform training for everybody. For the judicial selection, anybody involved in judicial selection. But okay, well, it is 3:42. And we're scheduled to end at 4. So we are still within our time. And I want to take a final, before I entertain the adjournment, I will take a final opportunity just to say thank you to everybody who has given me the privilege of working with you on COAF. And I can see that I told Esther She already has a great cast, supporting cast. The new people are already making recommendations and ideas, and they are participating. So it is really, really going to be a great COAF in the future as well. So she and Ryan will be excellent leaders. And I will say thank you to everybody before we entertain a motion to adjourn, but I'll entertain that motion now. And Elizabeth, I'm still gonna bug you about something. I'm gonna have to find something to send you an email about and everything too.
Anytime.
Ask you to do. I even have your cell phone number, so yeah, you can't get away from me. If nothing further, anything for good of the order? If not, I'll entertain a motion to adjourn.
I want the entry of that little girl back there.
I know, I just waved to her, but she's on the way back.
I'm sorry.
Say hi.
Hi, sweetie.
Hi, who's that?
That's my daughter, Ryan Jr.
Oh, wow, that is great. I think technically we do need a motion to adjourn on the Robert's Rules of Order.
I moved to adjourn the meeting.
Okay, who was that? That was Ryan. Who seconded? All right, we got a second. You've noted the second.
I'll second.
Okay. All right, and Genevieve says, thank you, Judge Brenda. Genevieve, thank you. Okay, very good, you all. Take care. Love you all. And good luck. Good luck.
We love you.
Yeah. We love you.
I want some balloons in the background. Fireworks and balloons. All right, thank you all. Take care. Bye-bye.
Thank you.
Bye.
Bye.
Bye.